Good morning.
Good morning, my lady, my lord. I appear on behalf of the appellant alongside Mr. Jamali. Miss Elliott represents the respondent. If I may begin with the usual housekeeping, just to check the court has the relevant papers that have come through. Kicking off with a core bundle of 116 pages.
Yes.
Supplementary bundle of 203. There were then two authorities bundles, for which I apologise. The first was 532 pages. A supplementary bundle of 62.
Is this the
reported version of the authorities, my lady?
No, I don't have that. I have just a further little clip, which is an unagreed bundle, which has one authority in it. But I just have one authorities bundle, which ends at page 532.
There was an omission within the original authorities bundle, my lady, where TUI, ULA and Gulale had not been provided in their reported form.
Okay.
And that's the only element that's been remedied.
Changed, okay.
That's correct.
And where will I find that?
That should be a separate bundle running to 62 pages.
Okay. But in the bundle as it is, what tab is the case in question?
So TUI was tab 4 in its unreported format.
Yes.
ULA was 7.
Oh, yeah.
Gulale was 11. So they are all in there, and I'm content to address the court on whichever.
For what it's worth, I've got the supplementary bundle electronically, but not hard copy.
Okay. So let's just carry on.
Right. And then, as my lady indicated, there was a final bundle sent in by the Secretary of State, which includes the authority of NR Jamaica.
Thank you.
Okay,
so, my lady, with that in mind, insofar as the appellant is concerned, if I can give an indication, only an indication, that I hope to be able to address the court within the hour.
Thank you.
The issue from the appellant's perspective for this court to consider is a single one, whether the first-tier tribunal...
Would you just wait a second? Sorry. Because we're just wondering whether we've got the additional unagreed bundle.
I'll get it
I've got
by the time you've
Thank
got
you.
to it.
Thank you.
Are you
Please do
content?
continue.
Thank you, my lady. The issue, as I say, my lady, from the appellant's perspective, is a single one, comprised of the question of whether the first-tier tribunal was correct to limit the evidence of the witnesses on the appellant's side by concluding that the respondent's refusal to challenge the principal controversial issues meant that the evidence from the two further witnesses was not required. If your answer to that question is no, and you find against the appellant, then it must follow that Judge O'Callaghan was entitled to interfere with the first-tier tribunal's decision, and this appeal must be dismissed. If, on the contrary, you find that the first-tier tribunal was so entitled, then the appellant's position would be that the Upper Tribunal had no basis to interfere with the first-tier tribunal's decision. This appeal should be allowed, and the first-tier tribunal's decision should be reinstated. Now, with that in mind, and with the indication that I intend to address the court for around an hour, I do propose to go through the factual chronology of this case in a little bit of detail. In particular, it's important to flesh out how we've ended up with Judge Carton's determination, starting with the historic determination from the tribunal in 2017, before I move on to address no more than 3 or 4 authorities. So, as the court is aware, the appellant, who of course is the subject of an anonymity order, came to the United Kingdom, or claims to have done so, in June 2006. The first substantive application that he's recorded as having made was one made in July 2012. There he advanced a claim based on his Article 8 rights. It is not in dispute that the appellant did not advance a claim based on his sexuality on that date. The application was unsuccessful, and then fast forwarding to February 2017, he received a conviction for sexual assault on a female. He was encountered by the police on the 31st of May 2017 and went on to claim asylum, relying on his claimed sexuality on the 22nd of June 2017. That application was refused. It was refused with a right of appeal, and the appeal came before first-tier tribunal judge Malcolm. Judge Malcolm's determination is in the supplementary bundle. And I will briefly take the court through if I may. So if the court has tabs, this is supplementary bundle tab 7. And for those working electronically, it's page 39 onwards. It is important to emphasise at this stage that the appeal hearing before Judge Malcolm predated the appellant's subsequent relationship with, and I'll call him if I may, Mr. K. The findings made by Judge Malcolm, which of course have the protection of the Diva Sealand guidelines, start from paragraph 100, and this is page 52 of the supplementary bundle.
Yes.
There are 7, from my view, key points that the judge made in finding against the appellant and dismissing his appeal. The first point, which is contained between paragraphs 104 and 108, is the effective delay in the appellant raising his claimed sexuality following his entry to the United Kingdom in 2006, and as the court is aware, the omission from the July 2012 application. From paragraphs, the second issue is then discrepancies in letters obtained by the appellant or for the appellant from Pakistan. Those findings really straddle from paragraphs 111 to 115. Paragraph 119, the judge found it incredible that the appellant would have been subject to a sexual assault when reporting a previous sexual assault to a police officer.
Sorry, which paragraph are you in there?
This is 119. 119.
119, sorry.
Thank you.
Sorry, maybe I just wrote it down wrong. This is something that starts at 111. You said you're in the number of points. Your delay was 104, etc. Then you said, I thought 111 to 115.
That's right. So we're now on to credibility findings.
So you're now on to a third.
So that's the third.
A third. I'm sorry. Okay.
My fault, my lord, entirely.
Okay.
The fourth of the 7 issues that I've identified is between paragraphs 120 and 121, and that is the absence of evidence from individuals who could speak to his problems based in Pakistan. The 5th issue is paragraph 122, where it was said that an inconsistent account had been provided as to why his then partner was unable or unwilling to give evidence. Issue number 6 of 7 is then paragraph 124, where the tribunal found that the witnesses were of limited evidential value, as they did not provide corroboration and were simply reporting information provided by the appellant. And the 7th issue is at 130, where the judge identified the perceived inconsistency between the appellant's claim to be a homosexual male and his 2017 conviction for sexual assault on a female. Those findings lend to the ultimate conclusion, paragraph 131, that to the lower standard of proof, the appellant had not shown that he was a homosexual as claimed.
May I just, sorry to interrupt, Mr. Gadger, may I just ask a question? On the question of whether or not the appellant is homosexual or gay, is that an issue on which the burden of proof lay on him and the standard is the balance of probabilities?
It would have been the lower standard at the time, my lady, given that this was decided pre-NABA. The burden would have been...
Well, is that right, though? Because the question of risk, I understand that the lower standard applies to risk on return, but whether or not he's gay is a fact. It's either true or it isn't.
Yes.
So my instinctive reaction would be that would be something he'd have to prove on the balance of probabilities.
It's not something I may just want to clarify that, my lady, and perhaps come back to that in reply. But the proposition is 131, as applied by the first tier tribunal at the time, was...
No, I understand.
Yes.
I understand that's what the FTT did. My question is, was that the right approach?
Perhaps if I can hold my fire on that, my lady,
Yeah, sure.
and come back to you on that. I'm grateful. Now, that concludes my summary of Judge Malcolm's adverse findings against the appellant. As the court will be aware, there was an application for permission to appeal. Permission was granted, but ultimately that culminated with Upper Tribunal Judge Hanson concluding between pages 29 and 38 of the same supplementary bundle that the first tier tribunal did not make an error of law, and as such the decision stood. That was the 21st of May 2018, where the Upper Tribunal found no error of law. And it is important to then identify that in 2019, the appellant claims to have started his relationship with Mr. K. One set of further submissions then followed on the 17th of February 2020. Those were met with a rejection on the 30th of September 2021. The court doesn't have those documents before it. And then we proceed to subsequent further submissions on or around the 30th of September 2021. Those further submissions were refused, and there have been a number of copies of the refusal letter, but the cleanest copy is provided in the respondent's most recent bundle.
Do we need to look at the further submissions? Is it, say, 30th of September?
That's right, my lord. So the further submissions do have a date on them in the supplementary bundle at tab 5, pages 22 to 28.
But that's the 18th of August.
That's right. So the date on them is the 18th of August, but I think they're treated as having been made on the 30th of September.
13th.
30, my lord.
30. Okay. But that's what we're talking about.
It appears to be the same document, that's right. Those submissions are relatively succinct. They detail at page 23 his history in Pakistan. At the middle of that page at 23, in the paragraph beginning, upon his arrival into the UK, it's outlined that he felt assured but was unable to or failed to apply for protection immediately due to his genuine naivety and scant knowledge of the immigration rules. At the bottom of that page, we have an indication of the relationship that then follows with Mr. K. Mr. K is described as a British citizen. His date of birth is given. And then across the page, there are matters that are of less relevance to this appeal because they deal with the situation in the country. Those further submissions were, as I say, refused on the 27th of January 2023, and we have that letter in the respondent's final bundle. Again, outlining the issues as identified.
I'm so sorry, Mr. Gadger. When you say the respondent's final bundle, do you mean the core bundle?
No, my lady, this is the bundle that includes NR Jamaica.
Oh, right, I'm sorry.
34 pages in total, I'm sorry.
Sorry, can we
No, it's my fault.
see if I can try and find it?
Oh, I'm sorry, my lord.
Yeah, okay, I've got that now. Thank you.
Now, the structure of that decision, looking at internal page 4, is the pagination in the bottom right corner. We have a heading halfway down that page of submissions that have been previously considered. It's a heading that acknowledges that his claimed fear of persecution at the hands of the state and non-state actors on account of his claim to be homosexual had been considered. And then what follows from the bottom of that page and throughout page 5 of the internal pagination is a series of extracts from the first tier tribunal's determination that we've just seen. So the first substantive point that the 27th of January decision maker took is internal page 6, where it was observed in the paragraph at the top of the page, just above the heading consideration of your asylum claim, that the immigration judge had failed to accept, and that should properly read, refused to accept your claim to be a homosexual man and found you to lack credibility, and your claim was subsequently dismissed. That was upheld, as the decision maker observes, and we know, by the Upper Tribunal on the 21st of May 2018. The Secretary of State below that paragraph then goes on to consider, and as we know, went on to grant a right of appeal, the further submissions that have been made. Taking the issues as I see them as being central to that decision, paragraph 18 of that internal decision considered several letters of support that had been provided and noted that all but 2 of them did not specifically mention the appellant's claimed sexuality. Paragraph 19 dealt with a letter that did mention his sexuality, but appeared to discount the weight that could be attached to that letter on account of the author of that letter not having travelled to the appellant's country of origin or having provided evidence to show that she'd met his family. In terms of the appellant's claimed relationship with Mr. K, that was considered from paragraph 20 onwards, with the evidence being that, or the conclusion being that there was no evidence of a substantial relationship being in place, pointing to the absence of utility bills, bank statements and the like, and there being no evidence that any approaches had been made with a view to registering their marriage in the UK. The conclusion that flowed from that can be seen firstly at paragraph 21, where the decision maker said that this supported the finding that the relationship was not genuine and that he would not face the risk of persecution in Bangladesh. Paragraphs 23 onwards then focus significantly upon background information that's not immediately relevant to this appeal. I'd note purely for the...
So where is the finding that the relationship is not genuine?
So we see that first appearing at paragraph 21, my lord.
Well, it just says supports the finding that.
That's right.
But does it actually... Where is the actual finding? Or is that it?
So paragraph 27 is perhaps a run-on from that. However, in the paragraph, or the sentence beginning, however, there is no evidence that would overturn the original findings of the immigration judge on appeal, or the original asylum claim remains unaccepted that you are living in the UK as a gay man who would face persecution. So within the protection section, that's all we have. But in fairness, and the need to read the decision as a whole, the conclusion made by the Secretary of State that the relationship wasn't genuine and subsisting can also be seen within the context of the Article 8 decisions that were made within that same refusal letter. So, my lord, perhaps the best place to look for that is paragraphs 36 onwards. Just above that, consideration is given, or reference is made to GN 1.2, which is the definition under the immigration rules of the partner. 37 observes that his previous representatives were contacted to provide additional evidence of the relationship, but nothing had been received. (38) is a nod to the definition within the rules, wherein it was said that he hadn't showed that his relationship was akin to marriage of at least 2 years. And then we have the conclusion there at 30.
I mean, that isn't quite the same as saying.
No, but the decision does continue, my lord, with additional material thereafter. So paragraph 42 and also paragraph 46, where it's squarely put within the context of paragraph EX1 of the immigration rules, which of course asks the question of whether there are insurmountable obstacles to a relationship continuing abroad. In the context of paragraph 46, the decision maker says that as you have failed to demonstrate that you are in a genuine and subsisting relationship in the United Kingdom with a British citizen, with that context in mind, my lord, my ladies, the next key document is then the witness statement that the appellant prepared for the purpose of the first tier hearing. That document is at pages 57 to 60 of the supplementary bundle, and that's tab 8 for those of us working on paper.
Sorry, you're going to have to repeat that. Sorry, I was writing at the
Not
time.
at all, my lord. So pages 57 to 60 of the supplementary bundle.
Yep.
Again, if I just briefly pick out some of the key points that were made by the appellant in this statement dated the 30th of October 2023. Paragraph 10, this is page 58, he explained why it was that in July 2012, when he made his human rights application, he didn't disclose his sexuality, outlining that he was apprehensive about discussing it with people and that he hadn't ridden himself of the fear associated with disclosure. And there was a lack of trust even of the UK authorities. He also talks about a lack of awareness within that particular paragraph. Paragraph 11 provides information as to why he says that he delayed his claim for asylum. The upshot of that paragraph is that he was new to the UK, lacked proper guidance, and was unaware of the avenues available to him. The paragraph straddling across pages 58 and 59, so paragraph 12, then outlines his position in respect of the assault for which he was convicted in 2017. And I think a fair summary of that was that he says he was travelling on a bus. The female passenger sat next to him, moved a little closer as a result of which his elbow touched her. There were accusations of sexual assault. He refers to himself as being clueless and being advised by his previous solicitor to plead guilty. Paragraph 13 is also important. It's a paragraph that addresses Judge Malcolm's concerns about the letters that have been provided in support. Judge Malcolm's effective query was that if the appellant had been sexually abused by a teacher at the school that he was at, the author of a subsequent letter from that school would have been expected to have said something about it. And at paragraph 13, the appellant explains why the judge effectively was wrong on that point. Paragraph 14 then says that he wasn't aware of the request for further information the respondent says was sent on the 9th of November 2022 about Mr. K's relationship. That, of course, being one of the issues raised in the refusal letter. Two final points for me to make. Paragraph 15 details his relationship with two previous partners. And paragraph 16, which was central to the appeal before the first-tier tribunal, provides some important detail about his relationship with Mr. K, including that it started in 2019, that he continued to reside with Mr. K, but that the relationship had had some ups and downs. The explanation for that being the illnesses cited within that paragraph.
And he's lost most of his evidence verifying the relationship
Laing,
because his phone was stolen. We don't know when.
Laing, yes, that's right.
But then he goes on to say, concluded it would not be suitable for him to be my witness. Is that because of his mental health issues?
I understand that's correct, my lady, yes.
But then by the time of the hearing, he was about
He comes forward, that's
willing
right.
to give evidence.
That's right.
So that his mental health issues got better.
That's an evidential question, my lady, that I'm afraid I'm not able to plug. I can say, given what was penned down by Judge Carton, that Mr. K was available for the hearing on the 16th of April 2024. Whether that was on account of his mental health improving or on account of a decision being taken to tender him nonetheless is not something I can speak to, but the factual point is, as my lady has said, that he was purportedly available in April 2024. That document, if I may, my lady, in terms of the appellant's witness statement, then leads us to the final document before Judge Carton's decision, which is the respondent's review. That's in, going back to the most recent bundle provided by the Secretary of State, and that's the one containing NR Jamaica. The respondent's review is at pages 20 to 23. Paragraph 2 is important in that respect, albeit it's one that's common. It does outline the parameters of the review and what is to be expected in the event of silence. It looks at the schedule of issues, it confirms that the skeleton argument and any accompanying material have been considered. It leans upon the reasons for refusal letter, and then in the final two lines says that any points in the asylum skeleton argument ASA which are not specifically addressed should not be taken as accepted by the respondent.
Sorry, I'm struggling. Where are you?
We're in the respondent's review at page 20, my lord, paragraph 2.
Yep. Okay. Sorry, thank you.
The counter schedule, which is where the respondent reviews the material put forward and confirms her position, is at pages 21 going on to 22. Paragraph 5 confirms that the respondent maintained the decision of the 27th of January 2023. There's express reference there to the appellant's witness statement of the 13th of October. That's the document we've just looked at, along with the additional materials provided by his friends. And then what we see thereafter is at paragraph 6.
I'm so sorry, I've now lost where we are. It's my fault. Could you just tell me which page it is, please?
We're page 21, paragraph 6. Thank you.
Oh, so it's in... Sorry, so we're still looking at the response review?
We are indeed, that's right.
Right, okay, sorry, my fault. I thought we were looking at a different document.
And the heading is the appellant a homosexual.
Yeah.
So what I was referring to, my lady, was paragraph 6.
Yeah.
But paragraph 5, just to remind you, is where there is a reference to the appellant's 13th of October 2023 witness statement. Paragraph 6 then deals with the one statement that was then available from Mr. K, with nothing more up to date from May 2021 at that point. Paragraph 7 deals with the other supporting letters, which were said not to touch upon his sexuality but focus upon his character. Save for the one individual who refers to a partner without naming him. And at paragraph 8, the author of the review deals with a GP letter and says that little weight should be placed on that, as there was no other evidence at all to support the cohabitation between the appellant and Mr. K.
Judge Carton had some observations to make about the GP's letter, didn't he?
Yes,
Is it a
that's
he or
right.
a she, Judge Carton?
Judge Carton is a male.
A man, okay, thank you.
Those observations are correct, my lady, but they are observations that flow slightly outside of what you read at paragraph 8.
Yes, all right.
And then at paragraph 9, you're remiss of me not to make that point. Of course, the reviewer does say that Judge Malcolm's decision still stands in light of the above, and the tribunal, i.e. Judge Carton, should not depart from these based on the evidence submitted. Article 3, which is paragraph 10, is of no relevance to the purposes of this appeal. And again, for completeness, the respondent invited at paragraph 11 that the matter proceed to an oral hearing. And at 12, it was said that the presenting officer appearing at the appeal hearing should not be prejudiced by the further submissions on the material issues other than those outlined in the review.
Well, what's the purpose of the respondent requesting an oral hearing?
That may be something my learned friend is in a better position to provide a clear answer on. It is something, my lord, that's certainly from practice commonly seen, and it indicates that the evidence is to be tested. Sometimes the terminology used in the review is the respondent wishes to cross-examine. Sometimes it's what we see at paragraph 11. But my learned friend may be able to speak more in terms of what the intention of the reviewer is, if I'm wrong on that.
Isn't there always an oral hearing of an appeal in the FTT?
The election can come at the time of filing the notice of appeal, where an appellant can elect for either an oral hearing or for the matter to be decided on the papers.
Yeah.
Beyond that, of course, if the matter to be withdrawn, with the Secretary of State taking the clear view that the entirety of the refusal letter or the principal issues in a refusal letter are no longer pursued, then an oral hearing would fall away in any event. So the utility of this is perhaps a different matter, but my learned friend may have more to say on that.
So it may be redundant, because if the appellant has asked for an oral hearing, the FTT isn't going to not have an oral hearing, is it?
I would be surprised if that were to happen.
Yeah.
Yes.
Okay, thank you. That's very helpful, Mr. Gadget.
I'm sorry, what do you say that paragraph 12 on page 23 means? The presenting officer at the appeal should not be prejudiced by making further submissions on the material issues other than those outlined in this review and the Respondent's Bundle and the RFRL. So does that mean they don't have to make any further submissions? Those documents stand? What does it mean?
Or is prejudice the wrong word? Do they actually mean the respondent shouldn't be prevented from making further submissions?
Or
Other
how
than
by
the
doing
ones-
so?
Or other than the ones, in other words, if it occurs to the HOPO to make further points at the hearing, he or she should be able to.
That's how I
What they're
read it.
trying to say?
That's how I read it, my lady, and that would link in with what was said at paragraph 2.
Yeah.
Those final 2 lines where it said that points in the appellant's Skeleton argument that had not been specifically addressed
Yeah.
should not be taken as being.
So it's just basically not very clearly written.
But the effect of it seems to be that it leaves the door open for the presenting officer
yes,
not to
yes.
be constrained by
Right.
the position taken in the review.
Yeah, so this isn't an exhaustive statement of our position, it's just an outline, as it were. Yeah, that's really helpful. Thank you.
Thank you, my lady, I'm grateful.
Thank you.
That brings me on to Judge Carton's decision. We're back now in the core bundle, if I may. Tab 14, page 92. Now, the structure of that decision, again, I will make up the time that we're spending on this when it comes to the arguments on the law. Paragraph 2 of the judge's determination at page 93, he outlines the decision under appeal and importantly acknowledges that the 30th of September submissions led to a conclusion. And then he quotes, "It remained unaccepted that he was living in the United Kingdom as a gay man and would face persecution on return." So the judge is aware of the central nature of the appeal. And indeed, or to put it properly, the central nature of the refusal letter and the core of the Secretary of State's case in this appeal.
Well, I mean, he says that at the beginning of paragraph 6, doesn't he?
He does indeed, that's right, my lord. So the first we see it as paragraph 2, and then the principal controversial issues. And that heading's important because it's parried over and used again by the judge when examining what it was that was put to the appellant in cross-examination. But as my lord observes, paragraph 6 identifies the principal controversial issues. And this is the notice point that the appellant says is important and that Judge O'Callaghan later discusses in his error of law decision. But just before we move beyond paragraph 6, I appreciate to a degree it's sucking eggs, but paragraph 4 properly directs himself, the judge properly directs himself that the burden of proving the material facts is on the appellant.
Yeah, so that's, I mean, it's quite a condensed paragraph, but the FTT judge appears to be taking up the point that I made. In other words, about future risk, it's the lower standard, but otherwise the ordinary civil standard of balance of probabilities applies. So I think that means
My lady, yes, that's right.
the FTT judge understood that the claimant, or appellant, sorry, had to prove on the balance of probabilities that he was gay.
My lady, yes, that's
Yeah.
right. So that's how I read that paragraph as
Yeah,
well.
well, that's really helpful, thank you.
Now, as my lord says, paragraph 6 then deals with the principal controversial issues. And in reality, whilst it's termed in the plural, it is condensed down to one question.
Well, I think that's probably a standard
Absolutely,
heading which comes from cases like LATA and the new direction.
I don't say that pejoratively to the judge.
No. I think it's just it's probably a sort of a conventional approach.
Of course. Now, paragraph 7 onwards to paragraph 10 then provide key information as to the judge's record of what happened at the hearing. And those are the ingredients that ultimately lead to the judge allowing this appeal. So he observed that the appellant was cross-examined, and he uses the words in a fashion. At the end of cross-examination...
It's astonishing that he needed an Urdu interpreter, given how articulate the witness statement is. The witness statement reads as though it's been written by somebody with excellent English.
There's something at the beginning of the witness statement which explains how it is
being produced. Was it done with was the witness statement done with an interpreter?
I've completed this statement through written communication and oral communication to confirm whether the content of my statement is correct.
Well, that doesn't.
I don't.
That doesn't say that an interpreter was used. It just looks like a very surprising discrepancy between the standard of English in the witness statement and the fact that he needed an interpreter when giving evidence.
I can see why my lady turns to that part of the determination. It, of course, isn't a live issue for the purposes of this appeal.
No.
But it also is, of course, possible that even those who are confident and comfortable speaking in the English language on a day-to-day basis prefer to have the protection of an interpreter when dealing with formal court proceedings. That's speculation to a significant...
Is there a requirement in these proceedings to do what you have to do in business and property courts of actually stating how the statement has come about?
The November 2024 practice direction, I think, brings about information that's required, but I'm not immediately sure if that's also required prior to that. It's not something I turn my mind to given the nature of the appeal, but I'm happy to look that up if it would assist the court. Now, besides the use of an Urdu interpreter, he's, of course, an individual who adopted his witness statement as the judge records. And thereafter, the judge sets out in some detail in the paragraphs that follow the interactions and communications with the presenting officer representing the Secretary of State on the day of the appeal. The presenting officer is, in effect, warned and alerted to the judge's perception that she had failed to raise or omitted to challenge, as he says at paragraph 7, the assertions made by the appellant that firstly he was gay and secondly that he was in a relationship with a man in the United Kingdom. The presenting officer evidently had the opportunity to respond to the judge's observations and is recorded as saying that she'd asked all the questions that she wished to. The judge observed, again this is the notice point in that paragraph, that it was his understanding that the respondent did not accept the truth of the matters. So the judge was clearly, in my submission, aware of the notice that the appellant had. He then goes on to say, as we see from paragraph 7, that if that was the respondent's position, that he took the view that fairness dictated that the case should be put to the appellant in order to give him an opportunity to respond. That is followed by the final sentence at paragraph 7, where the judge effectively warns the presenting officer of the likelihood of the appeal being allowed if there was no proper challenge, or no challenge, as he says, to be fair to the judge, to the principal controversial issues. Paragraph 8 shows that the judge was asked to rise, although he felt that was surprising, given that these were not complex or numerous issues. He nonetheless acceded to that request and allowed the presenting officer to take instructions. He records that was for around 10 minutes, and the presenting officer returned, and having had the opportunity to take instructions, remained steadfast in her position and confirmed that she had no further questions to ask but would be making submissions on the evidence heard and relying on the previous findings. And as the court sees, again, the judge points out, doing what the appellant says was more than required to put the respondent firstly on notice of his concerns, and secondly to give the Secretary of State's representative an opportunity to address the issues in question.
Now, the evidence heard would include the evidence of the appellant in his witness statement that we've seen, because he affirmed the truth of it in chief.
He'd adopted its contents manual, that's right, yes.
Right.
So within paragraphs 7 and 8, there are, I think it's fair to say, multiple instances where the judge has pressed upon the presenting officer the opportunity for her to cross-examine. And then we see how this crystallises at paragraph 9, with the judge saying that in light of the lack of challenge to the appellant on the principal controversial issues, i.e. paragraph 6, he indicated, that's the judge, that he did not require any further evidence to be called. Power would be exercised under Rule 14 to control the evidence, and the witness statements would not need to be called, with the note being taken instead. Submissions were heard from the presenting officer. There was no need to call upon the appellant's solicitor, Mr. Jegaday. And then, as we see thereafter, across the page, having recorded the submissions at paragraph 13, with the respondent relying on the refusal letter, the findings of Judge Malcolm, and submitting that the appellant had failed to demonstrate reasons to depart from those previous findings, the presenting officer is recorded as addressing the matters that followed, with little weight to be attached to the letters of support. The witness evidence said to be lacking in detail about his sexuality, and there being little or very limited evidence, as is recorded, of the appellant's relationship.
I'm so sorry to interrupt you again, Mr. Gadgett. Is the single-page letter from Mr. K that's referred to in paragraph 11 in one or other of the bundles, please?
I'm afraid it isn't, and that's an omission that, if the court permits, can be remedied now. I have this morning asked for copies to be provided if that would assist the court.
I think
It
that
is-
would be helpful, yes, please.
Happily, it's short, Melanie.
Well, yes, one gathers from the
Thank you.
determination that it's only a page long. Thank you. Thank you.
Thank you, Melanie. So that's the contents of the letter, and as we see, the challenge to the evidence at paragraph 13. It is important to highlight that at paragraph 14, the judge does properly consider and follow the guidelines given by the Upper Tribunal, or the Immigration Appeal Tribunal as it then was in Diva Sealam. 15 outlines in a fair but succinct summary Judge Malcolm's conclusions from the 11th of October 2017 determination.
Yes, it's a lot more succinct than the determination which you very fairly took us to. So thank you for doing that.
Not at all, my lady. But insofar as paragraph 15 is concerned, its succinctness is in my submission not a flaw. It does outline within that the overarching conclusions and treats those, as the judge says, as his starting point.
Yeah.
And we clearly see from the paragraphs that follow, especially those that deal with observations, that Judge Carton was evidently aware of the detail of Judge Malcolm's concerns as opposed to merely the overarching conclusions. But going back to the reasons why this appeal was allowed, Judge Carton, at paragraph 16, observed, my lord said, that the appellant had adopted his witness statement, and that was a statement in which he identified as a gay man living discreetly owing to his fears until he came to the UK, pride events that he'd attended, and at least 4 relationships with men in the UK. The cross-examination is dealt with, or a summary of it is provided from paragraph 17 and paragraph 18. Now this is key because what he appears to have been asked is first of all about his family in Pakistan and what contact he had. And secondly, paragraph 18, questions which appear to probe about issues as to when his relationship with Mr. K began, when they began cohabiting, and how and where they met.
And 2 of them expose inconsistencies in his account.
That's right. But what's key is to read that, my lady, alongside the subsequent paragraph, paragraph 19, where the judge observed that nowhere in the cross-examination was there any suggestion that his claim was a fabrication. In fact, the questions asked gave tacit acceptance of the claim to be in a relationship with and living with another man. And then again, the judge points within that paragraph to him having made clear during the hearing that that unchallenged evidence in these circumstances effectively led to the conclusion. Again, acknowledging at 20 the previous findings made 7 years ago by Judge Malcolm.
I mean, but by tacit acceptance, what do you understand the judge to have meant?
It seems to me, my lord, in fairness to the first-tier judge, that that's perhaps the A side of the coin that deals with the failure to challenge. But I see that, without of course being able to look into the judge's mind, as well, looking at the cross-examination as a whole and identifying that there was no challenge within it. And
so to give an example, I mean, I'd read that. If you look back at paragraph 18, which is the account of the cross-examination. So, for example, the second sentence, he was asked when he realised his sexuality. And if he was asked, if that records a question, when did you realise that you were homosexual?
Yes.
Then, if nothing is said, but it's not true, is it? Then it is. I think it may be said, well, that question tacitly accepts that the person is homosexual.
My lord, yes, and that's why, as you've done, one looks first at the question asked, but then also as a cross-examination as a whole. Because if the first question was, when did you realise you were homosexual? And then somewhere along the line it said, you're not really gay, are you? Then that first question wasn't tacit acceptance. But in the absence of the second element of the questioning, the challenge, as Judge Carton puts it, that's what I say is likely to have been the judge's reference when he talks about a tacit acceptance. The judge was at pains at paragraph 20 to emphasise the respondent specifically electing not to challenge the account given, despite me giving, as he says, ample opportunity to do so, and despite me pointing out the likely consequences of not challenging the evidence. He does make observations, as my Lady Justice Laing recalls, from paragraphs 22 to 25, where he says that had there have been challenge to the factual basis.
Well, before you go to 22, I mean, to pick up my lady's point to you, the first sentence of 21, is that the correct standard that he should have applied?
I will continue, if I may, to defer an answer on that, just to,
Okay.
to ensure that we're
Cool.
looking at the correct framework. But I can see, upon reading that and perhaps considering it across the page with paragraph 6, I'm so sorry, paragraph 4 that my lady had identified, the potential tension between the two. But I must emphasise, my lord, of course, that in the appeal onwards and upwards to the Upper Tribunal, the Secretary of State's focus was on the procedural elements and not upon the substance of the judge's decision per se, or indeed to any burden of proof that had been applied. So if I may return back to paragraphs 22 to 25, we see there that he said that if the Secretary of State had challenged the factual basis of the asylum claim, he would have shared Judge Malcolm's concerns about a number of things, one being the delay in mentioning his sexuality, the second being the sexual assault on a woman, those are the two things that can be carried over from Judge Malcolm's determination. Paragraphs 24 and 25 appear to be new concerns. They're new, it would seem, entirely, not just from Judge Malcolm's determination, but also from the Respondent's review. Because as my Lady Justice Laing said, whilst the Respondent's review did identify and deal with the refusal letter, the nature of the Secretary of State's concerns about the GP and the letter provided were a very different animal to that which we see at paragraph 24, which deals with the content, whereas the Secretary of State is looking to the absence of additional material to stand side by side.
The implication is that part of the letter is a forgery, isn't it?
It could be that that's the path the judge was going down, but he doesn't quite go as far as to say that.
Well, no, he doesn't. I said the implication. He doesn't make any express finding about it.
That's right.
But it's absolutely bizarre.
He identifies that the letter reads differently, as my lady has seen. But as he says at the end of that paragraph, this was a moot point. And key to all of this, and that's just before I move on to that, paragraph 25, and Dr. Simblet's evidence and the report provided. Again, this appears to be a new matter that is outside of Judge Malcolm's determination and also outside of the Respondent's review.
So what was the report of Dr. Simblet about?
I think the report of Dr. Simblet from memory touches upon his mental health.
Is it in any of the many bundles?
I believe it is, my lady, that's right.
Elliot's nodding. It would just be helpful to have a note of where it is, please.
My lady, it's in the supplementary bundle at tab 19, which
Tab
is
19.
page 77.
Thank you very
Thank
much.
you.
Oddly, I have tab 7, but I'm grateful to 11. The page is correct.
Yeah, okay, that's really helpful, thank you.
What I should emphasise at this point, before we move on to look at the grounds of appeal to the Upper Tribunal, is that the points that were carried over, and indeed the two new points that the judge had introduced, are not part of the reasons as to why the appeal was allowed. That appears to structure around the evidence provided by the appellant in his witness statement about his relationship with Mr. K. And so what we don't have, which would be perhaps more curious position, and I'll take it no further than that, is the judge saying the material in paragraphs 22 to 25, whilst I have concerns about it, has aided my decision in nonetheless allowing the appeal. They appear to be separate observations outside of the basis upon which the appeal was allowed. So that's Judge Carton's determination. I may have misled the court. I said an hour, but I will nonetheless.
I think we're seriously running behind now, because I think this is listed for half a day.
It is.
So we do need to press on.
I don't think I need to take the court through the grounds of appeal or Judge O'Callaghan's determination. That, I assume, is one of the key documents that the court has in mind. So with that background, and with the effect being that Judge Malcolm had dismissed the appellant's appeal, and subsequent to that, the appellant in his witness statement in October 2023 had addressed a number of the points relied upon by Judge Malcolm to dismiss his appeal. And given the brevity of the respondent's review, Judge Carton was presented with new material, and the overarching point that I'll make is that he was entitled, one, to allow the appeal for the reasons that he did, and secondly, to limit the evidence. Now, if I then move on to the authorities bundle, and we're looking at this stage at the larger authorities bundle, running to 523 pages.
Just before you go to the authorities, what do you say the test is in terms of our scrutiny of Judge Carton's decision? I mean, what's the test we apply to determine whether we should interfere with it?
Well, I think there are two limbs to that answer, if I may. The first is the usual caution and the deference that's afforded to first-tier judges in light of the fact that they were the ones who've heard the evidence and have seen the theatre show play out in that respect. And the second, I think, is I do agree with my learned friend insofar as it said that we're really looking at challenges on public law grounds, failing to consider relevant factors when exercising the discretion under Rule 14, alternatively reaching an irrational conclusion. That's what, in my submission, the Upper Tribunal should have been looking at when it determined whether or not it should interfere.
I mean, there is a finding of fact which is in fact reached again at the first sentence, paragraph 26, that the appellant has demonstrated to the lower standard that he's homosexual. I mean, that is putting aside the question at the moment of what the actual standard of proof should have been. I mean, if that is a finding of fact, you say we can interfere with it only on the basis of what?
The finding of fact wasn't the direct challenge of the appeal to the Upper Tribunal. It was the procedure that led to that finding of fact that was the challenge. And so with the grounds of appeal being advanced in the way that they were, and there were two elements to it. One was, in effect, a procedural fairness challenge, and the other was a bias point that was abandoned before Judge O'Callaghan. It's the procedure and the decision to limit the evidence in circumstances where Judge Carton found there hadn't been a challenge that was the true target of the Secretary of State's appeal to the Upper Tribunal. The finding at paragraph 27 that my Lord refers to in those circumstances is not the direct target, it's the consequence of the procedure. The ground, perhaps if I can put it in a slightly different way, I don't read the grounds of appeal as saying, even if the judge was right to limit the evidence, he was nonetheless wrong to allow the appeal for another reason. So the target towards paragraph 27 and the conclusion is only made out if the Upper Tribunal found a procedural error in the judge's decision to limit the evidence. If that answers my Lord's question, if I can then redirect your eyes to the bundle of authorities. The first of the three authorities that I intend to address the court on is the Privy Council's judgment in the case of Chen. That's in the large authorities bundle, tab 29 or 508.
Sorry.
508.
Chen.
Yes, please, God. I'm grateful. Now, I'll pick up the pace just in a bit to make up time. The position and the factual background to Chambers 1, in which there was a share ownership dispute, the defendant's account was disbelieved after cross-examination, but in circumstances where the two prongs upon which the trial judge disbelieved his account and went on to dismiss the defence were not put to the defendant during the course of cross-examination. The Privy Council and the Board in those circumstances asked itself the question from page 524 onwards of, was the judge entitled to disbelieve the defendant for the reasons that he gave? I think that's pronounced as Mr. Ing, but if I'm wrong, I apologise.
Sorry, so which paragraph, please?
From 48 onwards, but I'll move straight to paragraph 52, if I may. Page 525, please. So there are 3 points to extract from this paragraph, dealing with the starting point, which is, in a perfect world, any ground for doubting a witness ought to be put to him. The second is then, understandably, for the Board to highlight that the world is not perfect, but that the general rule should be borne in mind by those who cross-examine and trial judges, but that the requirement cannot be absolute in every case. The third is then the observation that in a very full trial it may be disproportionate or unrealistic to expect a cross-examiner to put every detail, especially in a complex case. And in the context of this particular set of facts, where the trial judge had rationed the time allocated to cross-examination and where the witness needed an interpreter. At paragraph 54, we see the Board's observations, this of course being Lord Manson and Lord Neuberger, that Mr. Ing was cross-examined on the basis that he wasn't telling the truth about the issue, that the challenge was more nuanced. And then the important factors to consider when it comes to interfering with a trial judge's decision that follow it towards the end of that paragraph, or the second half of that paragraph, that the decision as to whether to uphold a trial judge's decision to reject evidence which was not put to the witness must depend on the facts of the particular case, with the trial being viewed in an overall fashion, and the question being whether there was a fair hearing of the relevant issues. And at paragraph 57, the Board concluded that in that instance, it wasn't fair for Mr. Ing's evidence and for his evidence to have been rejected, with the 2 points not being put to him. Importantly, I'll also point out paragraph 58, where it was said that both, so this is just under halfway down that paragraph, it says both grounds could have been put very easily in the course of 90-minute cross-examination, even allowing for the other points relied upon by counsel and the need for an interpreter. So this case is the beginning of the authorities the appellant relies on to say the importance of witnesses being required to have proper notice of the concerns that were raised. The second of the three cases is then the case of TUI.
Sorry, but you say, what do you say is the content of the duty? Is it that a witness or the party has to have proper notice of the allegations put, or that they have to have the ability to deal with them in cross-examination? Because those two things aren't the same.
Those two things aren't the same. It's difficult, my lord, to answer that question in a concrete way, because as the board recognised at paragraph 54 in particular, what will be fair will depend on the factual circumstances of the case. And as my lord will recall from TUI, when looking at the exceptions to the Brown and Dunn principle, the Supreme Court identified a number of separate ways in which it wouldn't necessarily be required. One of those was if the evidence put forward was manifestly unbelievable. Another was if it wasn't on a significant issue. But then perhaps the closest to the factual matrix that we have here, or the most sensible one to rely upon, is that where, when dealing with an expert witness, the Supreme Court observed that if questions have been put in a sufficient manner, pursuant to CPR 35(6), that may be enough to then not require the witness to be called upon to answer those questions in cross-examination. So it's in reality likely a hybrid of the two, which ultimately leads to a conclusion of a question of fairness on the facts of the particular hearing. So I hope that answers my lord's question, but in terms of TUI, the second of the three that are relied upon by the appellant in this appeal, that of course, as the court is aware, is again factually distinct on the basis that it was a holiday illness case. There was only one report put forward in terms of causation. It's fair to say that Professor Pennington's report was deemed unimpressive in many respects, but it was ultimately unchallenged. Very briefly going through that, I'm sorry I didn't point out where this is. This appears twice. The reported version is in the 62-page bundle of authorities, the three authorities that were provided.
And the unreported is at tab 4.
My lady.
Yes.
A few brief points to make, which carry over, the appellant says, to this appeal. The first is to point to paragraph 36. That identifies the burden of proof being on the claimant. For those looking in the reported version at E, the Supreme Court, as we know, recognised that it's trite law for English law to operate an adversarial system. That's something which Judge O'Callaghan also referred to in his own judgment. And the role of the parties, as Lord Hodge said at E, was to frame the issues for the judge to decide. In their pleadings, and this part in my submission is important, and their conduct in the trial.
Sorry, which paragraph is that? It's my fault.
It's paragraph 36, my lady.
Thank
If you're looking
you
at the
very much.
reported version, it's around letter E in the column.
Yes, I was just hunting down the reported version.
I don't have the reported
Took me a
version,
while to
so
find it.
Where are we? Which paragraph?
Paragraph 36, my lady.
Thank you.
Thank you. For the sake of completeness, I'll also draw attention to paragraph 56 onwards, where the Privy Council's judgment in Chen, which we've just been looking at, was referred to at length by the Supreme Court. And then, and I'll be brief on this because I've just addressed my Lord Justice Snowden on the exceptions from paragraph 61 onwards and up to 68, the Supreme Court had set out various potential exceptions to the requirement that matters are put in cross-examination. The matter that I've referred to, the CPR 35(6) questions point, is at paragraph 67. There, Lord Hodge details one exception where an expert has been given sufficient opportunity to respond to criticisms or otherwise clarify his or her report. Sufficient in my submission is key. And finally, paragraph 76, we reach what's about to be the sort of global conclusions by the Supreme Court in saying that both the trial judge and the Court of Appeal didn't consider the effect on the fairness of the trial of TUI's failure to cross-examine Professor Pennington. As I say, as the Court is aware, insofar as that is concerned, Professor Pennington's report did contain what was said to be, in my paraphrasing, shortcomings. And I'm sorry to go back, but just going back to paragraph 69, one point that does arise again, reflecting the flexibility with a view to maintaining procedural fairness. Lord Hodge identified that the rule is a flexible one and that there may be circumstances in which a witness needs to be recalled for the purpose of being cross-examined on a matter that counsel had omitted. That's authority 2 of 3.
I mean, the principles are set out at 70. That's the summary of the Supreme Court's view of the principles, isn't it?
My Lord, yes, and if you're looking at the reported version, then I hope that's been sidelined, but I acknowledge the
has, yeah.
version hadn't. But for the sake of speed, if I can perhaps just highlight paragraph 70 as a relevant consideration. Again, it talks about adversarial systems, the maintenance of fairness and the exceptions to the rule.
I mean, usually the situation which arises isn't the current situation. I mean, normally what happens, as was in Chen, I think, is that a judge makes a finding of dishonesty or disbelieves a witness, says their evidence isn't credible, and cites, say, half a dozen facts or points. And then the witness who is outraged that they've been disbelieved say, well, one of those points wasn't put to me.
My Lord, yes.
I mean, that's the normal sort of scenario that I think they were dealing with in Chen.
Indeed, and that carries over to the Griffiths and TUI judgment.
Yeah.
In reality, my Lord, what that reflects is, if TUI, which is of course binding authority, is correct on the point, then Judge Carton has done what TUI required. And as I said at the outset of my submissions, there was no basis for the Upper Tribunal in those circumstances to interfere with his decision, based both on case management and Rule 14 limiting the evidence, and allowing the appeal in the absence of...
I mean, do you need to go further than saying it was a course that was open to Judge Carton to do, and because it was open rationally for him to do what he did,
Yes, ma'am.
It shouldn't have been interfered with?
My Lord, yes. It falls within a range of reasonable options available to a first-tier judge who has the advantage of hearing the evidence and seeing the trial play out in a way that the Upper Tribunal doesn't. If I may, with that, move on to the final, which is the case of Ula. Ula, and I don't say this for any other reason than for the sake of facts, I'll say the page first. So it's in the shorter bundle with the reported authorities, it's 34.
And it's 7.
I'm very grateful, my lady, thank you. Ula, the appellant says, is material for a number of reasons. None of those reasons include the fact that that panel was made up of Judge O'Callaghan, including sitting with Upper Tribunal Judge Norton Taylor. But it's important because it introduces and confirms in Lord Justice Green's judgment that the issues discussed by the Supreme Court in TUI apply in equal force to public law. Ula, very briefly, was a decision taken by the Secretary of State for the Home Department which deprived Mr. Ula of his British citizenship on account of the fact that shortly after naturalising as a British citizen, he pleaded guilty to possession of criminal property for criminal acts which were carried out before his application for naturalisation. Yet, when asked in the naturalisation application the broad question to the effect of were there any reasons as to why the Secretary of State may think that he wasn't of good character, he answered no, despite having carried out criminal offences prior to that. The Secretary of State deprived him of his nationality by relying on Section 40, subsection 3 of the British Nationality Act 1981, and in doing so, expressly therefore relied on false representations, and the case was centred around an allegation of dishonesty. That carried a right of appeal. The appellant, represented by Mr. Malik, King's Counsel, was examined in chief, and the examination in chief culminated in him saying that, in effect, he wasn't dishonest, didn't understand, and he put forward an innocent explanation. Key in this case, as Lord Justice Green sets out in the summary of the case at paragraph 2 of his judgment, was the fact that, much like this case, there was no cross-examination on that point, on that specific point. On account of the absence of cross-examination, the first tier allowed his appeal. The Upper Tribunal, like in this case, went on to set that aside, and this court found in favour of the appellant. The key paragraphs in ULA that I'd invite the court to consider start off at paragraphs 24 and 25, which set out the narrative of the first tier tribunal's decision, and perhaps indirectly now responding back to my Lord's question about the case upon which the Upper Tribunal should interfere with the first tier tribunal's decision, we have paragraph 26 onwards, which sets out the Upper Tribunal's jurisdiction when it puts on its hats dealing with statutory appeals and errors of law. At paragraph 36, Lord Justice Green introduced the Supreme Court's judgment in TUI, and for the purpose of my submission, Mr. Malik's argument made at paragraph 39 that although TUI concerned evidence in civil proceedings, the principle applied a fortiori right to the field of public law was agreed by Lord Justice Green, as we see in the pithy final sentence of his judgment at 39. And importantly, as TUI itself outlined, that guidance applies not just to expert witnesses, but also the witnesses of primary fact. Finally, paragraph 44 is a paragraph I'd invite the court to read. It's the summary conclusions, and it identifies, in the same way as the appellant says occurred in this appeal, the missed opportunities by the Secretary of State to cross-examine on the principal controversial issue in that case. With those authorities and that factual matrix in mind, if I can leave the court with this final set of points. In those circumstances, the appellant's position is that Judge Carton's decision on his conduct of the trial was not only not procedurally unfair, but it was in keeping with TUI and in keeping with ULA, which brought in the guidance from TUI into the public law context. This is not a case that in the appellant's submissions can fall within the exceptions to the rule that we saw from paragraphs 61 to 69 of TUI. These were not insignificant or collateral issues. The evidence the appellant had put forward that this court has seen in his witness statement from October 2023 was not manifestly incredible. This also wasn't a case in which the judge's case management and rationing of time meant that there was a limit imposed upon the presenting officer for the Secretary of State, and quite to the contrary, we see what reads in my submission as the exasperation of the judge continually and repeatedly inviting the Secretary of State to ask the questions that he felt had been omitted, identifying to a category at the very least what those omissions in cross-examination were, and even affording the generosity of rising in order for the presenting officer to take instructions. This is also not a case, just pressing upon the point I've made earlier, where it can be said that the review, or indeed the refusal letter, was such that this falls into the, if I can call it, the 35-6 example of where an expert has had sufficient opportunity in Rule 35-6 scenarios to answer questions. The review, as the court will recall, touches upon the witness statement, but does nothing more. When the Supreme Court said, in its judgment at paragraph 67, that an expert needs to have been given a sufficient opportunity, it cannot, in my submission, have meant to have merely flagged a witness statement and said, well, nonetheless, we continue to maintain the stance taken in the refusal letter and we stand by and we ask for an oral hearing. The Upper Tribunal, and what then follows, going back to my Lord Justice Snowden's questions, is the tacit acceptance point. There was no challenge to that tacit acceptance within the Secretary of State's grounds of appeal to the Upper Tribunal. It doesn't bear, in the one document I haven't taken you to, and no doubt Malone and Friend will press upon, is the immigration officer, the presenting officer's notes of the hearing from pages 24 to 26 of the NR bundle, the bundle finally supplied by the Secretary of State. But the court will be familiar with the summary of that because it was touched upon in detail by Judge O'Callaghan in his judgment. There's no challenge to the position taken in terms of tacit acceptance. And the judge's exploration of whether the appellant had sufficient notice and his observations that Judge Carton doesn't appear to have turned his mind to that are with respect not borne out by Judge Carton's determination, which at least at paragraphs 2 and 6 identified what the principal controversial issues were from the refusal letter in question. On the tacit acceptance point, and I think subject to anything Mr. Jamali may invite me to say, this will be my final submission. This is not a case related to concessions. This is a case not just about the questions that were not asked by the presenting officer, i.e. the omissions in cross-examination that Judge Carton outlined, but it's also about the questions that were asked and how, in my dialogue with Lord Justice Snowden, standing back, the judge read those as amounting to a tacit acceptance. The final sentence I'll make before I take my seat is the respondent's position in this appeal has been that what Judge Carton should have done is to have asked the questions himself. And in my submission, the short answer to that is doing so would have led to the judge doing the impermissible by
Descending into the arena, yeah, absolutely. And all the more so in a situation where the presenting officer has not asked the questions despite being invited to.
My lady, yes.
Yeah.
So with that in mind, and apologies for the slightly more prolix submission than I'd indicated, unless there's anything else, I'd invite this appeal to be announced.
Thank you.
My
Miss Elliott.
ladies, my lord, I'm grateful. I'm obviously also conscious of the time, that we're half an hour behind. Obviously, I have a respondent's notice point to make as well as responding to my learned friend submissions. I'll endeavour to cut my cloth accordingly, but obviously the court's aware of the situation that we are in. Before I go into my plan submissions, just a quick point to make, which is what is the scope of my learned friend's appeal for which he was given permission. It related to the single ground set out in his grounds of appeal, which is at tab 2 of the core bundle. on page 15. And the paragraph which set out the single ground was that the Upper Tribunal has failed to consider a material factor, which is the tacit acceptance point. No ground of appeal was permitted which challenged the Upper Tribunal's assessment of notice and the line of authorities resulting in TUI. And my learned friend's skeleton argument certainly didn't make the submissions that he's made today. That's unsurprising in circumstances where the Upper Tribunal itself didn't consider whether notice had been sufficiently given to the appellant in this case. It just held that the FTT erred because it had failed to conduct the notice exercise itself. And you can see that from the relevant paragraph of the Upper Tribunal decision, which my learned friend didn't take you to, but obviously that the court will remind itself of, and the relevant paragraph. My lords and ladies will forgive me, I'm having technical difficulties.
Sorry, I'm struggling a little bit to follow the point you're making, and I'm sure it's me. Can you just go a little more slowly about the point you're making about the scope of the appeal?
Yes, my lord. So the scope of the appeal was whether the Upper Tribunal failed in reaching its decision to take into account a material factor. And in the grounds of appeal, that material factor was identified that the Upper Tribunal didn't see that the tacit acceptance wording in paragraph 19 meant that the FTT had gone further than just saying you've not challenged evidence. It went beyond that to say you've actually accepted the account of sexuality. That's what the ground of appeal was on which permission was given. And as I've said, my point is that if my learned friend is inviting you to conduct an analysis of the procedural fairness authorities culminating in TUI, that's not within the remit of his ground of appeal. It's a different line of argument, and it's not necessary for this court to go there because the Upper Tribunal didn't conduct the analysis about whether notice had been given or not. My learned friend's submissions to you were effectively, well, he wasn't given sufficient notice. Well, the Upper Tribunal properly made no findings on that. It said it was sufficient that the judge hadn't actually engaged with the reality itself, and that was what it had erred in doing. That is the submission so I make. I'm prepared to address this court on TUI because I anticipated from my learned friend's sidelinings that he might do this. But I just want to make the point clear that the Secretary of State is concerned that the case that is being evolved goes beyond what this court is properly tasked with doing on this appeal. Dealing briefly with my Lord Snowden's questions about what is the test that this court should be applying, the target of the appeal, as my learned friend fairly said, is the exercise by the FTT of its discretion under Rule 14 of the FTT rules. That is the power that FTT J. Cartin invoked to dispense with the remaining witnesses, including Mr. K. And the test that you apply when you're considering whether that decision was erroneous is that set out in my skeleton argument at paragraphs 28 and 29. As my learned friend said, it's effectively public law test. If a decision to exercise a discretionary case management power was vitiated because of an error of law, including the failure to take into account relevant factors and disregard irrelevant ones, then that decision to exercise that discretion will be flawed, and the substantive determination that flows from that may be set aside as the product of procedural unfairness. And that is why the Secretary of State says that because of the error in exercising the Rule 14 discretion, so the failure to actually properly direct, the failure by the FTT to properly direct itself as to what its problem was, in layperson's terms with the Secretary of State's conduct of the FTT appeal, that its then decision about the substantive claim was unsafe and failed to be set aside in the way that the Upper Tribunal eventually did. And there are authorities referred to in those paragraphs, which, because of the time, I won't take the court to, but they are.
Oh, are we missing? Sorry, it may be just me, and I apologise if it is. I mean, we're dancing around seems to me we're dancing around a bit here. The first tier tribunal said, I will not let you submit to me that the appellant should not be believed when he says he is gay and in a gay relationship, because you have not put that point to him. And everything else flowed from that, didn't it?
Well, effectively, what the FTT did was say, well, this is uncontroverted evidence and I accept it. And it was on that basis that
in other words,
he proceeded to determine...
That's right. In other words, you putting it in terms of the conventional Brown and Dunn rule, this is a conventional application of Brown and Dunn. I will not allow you to submit to me at the end of the day that he should not be believed on his evidence because you didn't put to him that he was telling a lie in his evidence when he said he was gay. And
yes, my lord.
Because you're not allowed to do that, any other evidence on the point is just irrelevant.
That is what the FTT judge appears to have thought was the correct approach,
Right.
and the Secretary of State does not agree that was the correct approach.
But that's, as I see it, the main issue that we've been grappling with.
So the Secretary of State's position is effectively that you are not, that the law does not require you to cross-examine a witness in the way that the FTT judge thought. And even if it were, the decision based on that to then dispense with the hearing of evidence from crucial witnesses, in particular Mr. K, because of that, was not a proper course of action, particularly in circumstances where this is a specialist fact-finding tribunal tasked with assessing whether someone is eligible for protection under the Refugee Convention. And that is effectively the heart of the Respondent's Notice ground that I will be addressing you on. So, because of time, and because my learned friend did much of the heavy lifting in respect of the background documents, I'm not going to address them in any detail, but the points that I would make on the background before moving on to the substance are as follows. Going back to, or picking up a point I've just addressed with my Lord Justice Snowden, the Secretary of State's position is that hearing the oral evidence of Mr. K would have been significant to the determination properly of the asylum claim, because he had only submitted a late one-page letter. It is a letter, it's not a statement in any form that the tribunal would recognise, setting out its evidence which no one had had the opportunity to interrogate, because it post-dated the refusal decision and it post-dated the review decision, and obviously a copy has now been provided for it, and the tribunal deprived itself of any opportunity to assess Mr. K's credibility, which it likewise had never had the opportunity to properly consider. In fact, his letter evidence is not really addressed, other than saying a late one-page witness statement was provided. Now, another additional point, and I'll take this very briefly because of time, is, as my learned friend said, you have as another document, and so did the Upper Tribunal, the Home Office Presenting Officer's minute of the hearing, which is in the additional document bundle, so the NR Jamaica bundle, at page 37. Sorry, not 37. 24.
I was going to say it's 24, isn't it?
Yes, my lady, I'm grateful. As I say, my lady, I'm having technical difficulties, which
Are
will
all the
probably...
relevant bits of the minute reproduced in the Upper Tribunal's determination?
My lady, yes, which is why I'm not going to take you through it in any detail, but just to say that it's not disputed that the FTT summarises the questions asked fairly. But you will see from that note, and I think it's fairly recorded in the FTT's decision, that the Home Office maintained the principal controversial issue of whether the appellant was gay as a live issue, and didn't ever make any concessions in that respect. And I know that my learned friend has clarified that his case is not that this was a concession, formally speaking, which is important because the authorities show that there's clear difference between a failure to challenge evidence in cross-examination and concession of an issue, which means that the tribunal therefore does not have to determine that issue for itself.
So what you've just basically said is it's not been suggested that what the presenting officer did was to concede that the appellant was gay. It's just that by failing to or refusing to cross-examine and put the point to him that he should be disbelieved when he said he was, that the tribunal judge said, in which case, you can't make a submission to me.
There's a difference in my submission. If the principal controversial issue is whether someone is gay or not, that issue remains live until such point as it is conceded, and it wasn't in this case. Even if the FTT judge had proper concerns about the conduct of examination and properly thought that he couldn't put his own concerns to the witness himself, and I'll come on to that, whether that was a legally correct position, he shouldn't have effectively thrown in the towel on that issue and just accepted, without consideration of the further evidence, that the principal controversial issue was basically determined on what the appellant had said. Bearing in mind, obviously, that this is an asylum case to which the anxious scrutiny standard applied, and I'll be taking the court to some authorities in respect of that.
I mean, maybe anxious scrutiny, but these are still adversarial proceedings.
But in the context, my lord, and it is a different context of the FTT as a specialist fact-finding tribunal in immigration proceedings, and again, I'll be coming on to that point.
Well, I know it's a specialist fact-finding tribunal in the sense it has special expertise, but it's still conducting an adversarial process. It's not an inquisitorial process, is it?
No, my lord, but an adversarial process. So the core of the authorities on TUI that my learned friend took you to, so I believe it's paragraph 36 where we have trial law repeated 3 times, is that the parties in adversarial proceedings identified the issues in dispute. The court is not, or the tribunal is not required to formulate issues on its own. But that's different from evidence. Even in civil proceedings, if a judge has concerns about credibility, the authorities that I'll take you to don't say, well, a judge has to sit on his or her hands and not raise it at all, even if it's not considered that the opposing counsel, whichever side that may be, has not put that point properly in cross-examination.
But, I mean, the parties here had identified as the central issue in their in the document that was referred to, the review document and the schedule of issues we've seen, they both, in terms, said that the issue was the same. Is the appellant a homosexual?
Yes.
I mean, that's what they both said it.
Yes.
That was
and my
that
learned
was the
friend
issue.
fairly accepts that it was the principal controversial issue. I mean, my lord, going to the nub of it and whether the FTT's criticism of the presenting officer's conduct and how she cross-examined was correct. The description of what was not done is, I believe, in paragraph 19 of that decision.
I'm sorry, paragraph 19
of the FTT's decision, my
Okay.
lady. Yes. So that's on page 96 of the core bundle. Nowhere in cross-examination was there any suggestion that the claim was a fabrication. So what appears to be the FTT's complaint is, well, you didn't say to him fairly and squarely, you're lying about your sexuality, aren't you? And the Upper Tribunal reflects at paragraph 36 in its decision about why that might have been the case, because of the sensitive context, it being an asylum case, and the Upper Tribunal didn't comment sort of, yes, the Hoppo did what she should have done or not. But my submission is that the criticism that the FTT made of the cross-examination was not correct, to the extent that paragraph 19 reflects what the perceived deficiency was, which when you didn't ask him he was lying. The Hoppo in my submission wasn't required to say in terms, you're lying about being gay, aren't you? It's not a case like in Ulla, which my learned friend took this court to, and which we'll come back to, where the case relies on a finding of deceit or dishonesty. It is a question about the proof of the factual matrix of the appellant's asylum claim to the relevant standard, which should have been the balance of probabilities, as my lady Justice Laing identified, because it's a matter of fact. And in any event, nothing helpful evidentially would have been gained from that question, aside from potentially placating the first-tier tribunal judge, because the appellant would have simply have said, no, I'm not lying, because that was his case, and that was his asylum claim. And my lady, the authorities, my lord, my ladies, apologies, this isn't an authority before the court, but there was a case of Re B which looked at allegations or cases where lying was sort of part of the background, which I know my lady Justice Asplin will be familiar with because it's a case of hers. And the question there was, as in TUI, was there proper notice? Not that you have to go around accusing witnesses of lying when you're saying that their account is not proved on the balance of probabilities, if it's not needed.
But, sorry, I mean, I think the way it's put against you is unless I've misunderstood it, really quite straightforward. The main issue that the parties both identified was the single question, or sorry, the main question was, is the appellant a homosexual? He gave evidence in chief in his witness statement that he identified as a gay man.
Yes.
That's paragraph 16.
Yes.
Paragraph 19, nowhere in the cross-examination was there any suggestion that this claim was a fabrication. And in fact, there is the questions that we identified appeared to be based upon the proposition that he was. And in those circumstances, the first-tier tribunal judge said, if you are going to ask me in closing to disbelieve the evidence that the appellant has given in his witness statement, then you need to put it to him that he's lying. And the first-tier tribunal judge gave the presenting officer several opportunities, or an opportunity to do that, which the presenting officer did not take. Was the first-tier tribunal judge wrong in the sense of being irrational to take that course, and if so, why?
So, my lord, as I said, that in a case which is not about deceit, you do not have to put directly to the witness, you are lying, because that's not a finding that the tribunal in this case was required to make. It was required to assess whether on the balance of probabilities, in the context of this being in a second asylum claim, where diva sealing applied, whether or not he had made out to that standard that he was gay. And questions were asked which identified inconsistencies in his account in support of his being gay. And my learned friend took you to the paragraphs, I believe the key one is paragraph 18, where inconsistencies were identified in cross-examination, such that the Hoppo relied upon them in her closing submissions, which are again fairly recorded by the first-tier tribunal in 13, that the account wasn't credible.
So your point is that it wasn't an essential part of the principal controversial issue that the now appellant was lying. The issue for the FTT was whether on the balance of probabilities he had satisfied the FTT that he was gay. And in making that assessment, the FTT should have taken everything into account, including the coda, hours 22 to 25. But by taking the course it did take, it prevented itself from doing that, as well as testing the evidence of Mr. K.
My lady, yes.
Yeah.
Yes, that is a fair sum.
Where do why do you draw the distinction between a case which you say is a case of dishonesty on the one hand, or to simply a case where the fundamental issue necessarily means that the defendant is lying?
So,
where do you get that from? When we looked at the authorities, I thought I saw, and I can't find it at the moment, that the authorities indicated that the principle is broader than limited to cases of dishonesty.
Yes. So I think I would distinguish between what those are addressing and what I am trying to address in my submissions, although possibly not as clearly as I should be. So Brown and Dunn, the authorities, including TUI, established that Brown and Dunn rule applies regardless of whether the point that has not been put is dishonesty or not, because it had been argued in some cases that, well, the Brown and Dunn rule only applies in cases where a finding of dishonesty is required. Now, I don't take issue, the Secretary of State doesn't take issue with that principle. As I say, we don't get into was there notice or not here, because the Upper Tribunal didn't either. What I'm saying is what is required in cross-examination is conditioned by the applicable test. And in this case, the applicable test was on the balance of probabilities, have you established that you are gay? What was relied on, the material change in circumstances from the 2017 proceedings, was the relationship with Mr. K alleged to have started in 2019. So what was required to be interrogated was, well, has that account, that 2019 relationship, been proved on the balance of probabilities? So what was required of the Home Office presenting officer was to interrogate that account, and it is clear from the cross-examination that that is what she did, because in response to her questions, inconsistencies were identified. Now, it may be that in an ideal world, the HOPO would have made all those questions, identified all the inconsistencies, and then put it to him, you're lying, aren't you? And it may be that she should have done that when the FTTJ gave her the opportunity. But the Secretary of State's position is that she, one, wasn't required to do that, and two, even if she had been, it was not then a correct approach, and this is my respondent's notice ground, for the judge to take the position he did, which is, well, that's it, nothing else to see here, his account is uncontroverted, effectively in its entirety, he's entitled to protection under the Convention. And that is because what happened was not a concession of the principal controversial issue.
Well, it wasn't a concession, but it undoubtedly was an assertion on which the evidence of the appellant was... Sorry, the evidence of the appellant was directed to the main issue between the parties. It necessarily would follow, wouldn't it, that you were inviting the FTT judge to disbelieve it, because he says, I'm gay and I'm in a gay relationship. You say he hasn't established that to the requisite standard.
Yes.
Isn't that in essence saying he should be disbelieved?
I think...
And if he is to be disbelieved, then why don't we run into all the principles that were set out in paragraph 70 of 2E?
Well, because we don't have an FTT finding based on him lying, which is the point my lord made to my learned friend earlier, which is his argument is slightly putting the cart before the horse, because we didn't get to a finding which made an adverse asylum decision based on points which the Home Office presenting officer hadn't put to his client in evidence. We ended up in a situation which had nothing to do with that, which was, I've dispensed with I basically, with respect to the FTTJ, I'm not going to conduct the analysis which I'm required to on an appeal which is looking at eligibility for protection under the Convention, which is, I personally, as the judge, need to hear all the evidence, hear the cross-examination of Mr. K, and then come to my own position. And without wishing to sort of speculate too much, if the judge had said, I've heard all that evidence, I gave the opportunity to the HOPO to say that it was a fabrication, she didn't, that's one of the factors I take into consideration, we probably wouldn't be here. But we are here because in making the Rule 14 decision, the judge cut off the appeal about halfway through and acted as if a concession had been made when it hadn't, and that's not the case. It's being put to this court.
Well, I don't think the judge did, at least at the moment, I don't see the judge acting on the basis that it was a concession. What the judge was saying is, if you're not going to put to the actual witness whose status and evidence is directly being disputed, i.e. where he says, I'm gay, I'm in a gay relationship, that's the central question. You're not going to put it to him, but you are going to, at the end of the day, seek to ask me to disbelieve that evidence by making a finding that he's not in fact gay, then you simply can't do that. And what is the purpose of having further evidence on a point when you can't make that submission?
And Ms. Elliott, you're saying he should have looked at all of the evidence available to him in the round in order to determine the issue of which the actual person's evidence, which he may have said was not properly challenged, was one aspect.
Indeed.
But not the end of the story.
No.
That is what I understand.
Yes, my lady, yes.
Yeah, and the submission that's sorry to interrupt again. The submission that's recorded in paragraph 13 is precisely the point you're making. It was submitted the appellant failed to demonstrate there was a reason to depart from those previous findings, and then various examples are given. So the Hoppo isn't making a submission that's inconsistent with the failure to put your lying to the appellant. That's not the case she's making.
No, not the case she had to make.
No.
Unlike in Ulla, where you did have to make that. In fact, the burden in Ulla was on the Secretary of State to prove once a reasonable explanation had been given that it wasn't reasonable. And I think to deal with my lord's point about what the FTT was doing, I mean, if you go to paragraphs 15 and 16 in my submission, where you see that effectively what happened was as if a concession had been made, because at 15, which is on page 96 of the core bundle, the Diva Seelan retained findings, to use that term, from the 2017 decision are recited, but then it goes to say, however, the appellant adopted his witness statement as his evidence in chief, and then effectively says, then goes with some reciting of the evidence, including inconsistencies, which are then completely dropped. They're never dealt with again in the decision. 19, nowhere in the cross-examination was there any suggestion that the claim was a fabrication. So effectively what the first-tier tribunal judge did was say, despite this credibility issue in 2017, we have an adopted witness statement. I don't consider it a challenge, and that's that. That was not a proper assessment of the evidence, which this judge was required to carry out, respectively. And my lord and my ladies, I'll take you very quickly to some authorities which I say support the Secretary of State's position about why a failure to properly challenge evidence is not the same as a concession, which is the way the FTT behaves if it were. So we go into TUI again, which is at tab 4 of the bundle on page 28. Or 28 is the paragraph I'd like the court to look at. 38.
Sorry, back at 2, yeah.
Yes, so tab 4 of the authorities bundle on page 28.
Or tab 1 of the extra ones.
Yeah, my lady, I'm afraid that I do not have
right.
ones. So,
and which paragraph are we looking at?
38.
Thank you.
So this is in the context of the Supreme Court's recital of all the case law on, I'll call it the Brown and Dunn point, although as the Supreme Court pointed out, it was actually older than Brown and Dunn. And the sense is that the court below observed that a previous judge left open the possibility that a bald statement of opinion might assist the court if it is uncontroverted. I doubt that it would unless the opposing party could in the circumstances be taken to have admitted the accuracy of the conclusion, thereby relieving the judge of the task of evaluating the opinion or statements. So that's the point that my Lady Justice Elisabeth Laing made, is that because evidence isn't challenged doesn't mean that you as the judge shouldn't assess it for yourself. And then we have the additional authority of NR Jamaica, which is in the final bundle. And the relevant paragraph I would invite the court to look at is paragraph 10, which is on, if you're using the soft copy.
Sorry, when you say the final bundle?
That is the short clip of documents that included the review decision
Right.
that my learned friend took you to previously. And it's the last document in that little clip. And paragraph 10 is, if you're using PDF, 31, and if you're using a hard copy, it's page 29.
Yeah.
And this, by way of brief summary of the facts, is a human rights appeal against deportation, where one of the grounds advanced was risk on return due to sexuality, as in the present case. And the presenting officer made a series of concessions on the issue of sexuality, which the Secretary of State then sought to withdraw. And the relevant passage is paragraph 10. And here this court cites with approval guidance given in the unreported case of Carsabrook, and the relevant section is in that quote, which I'll invite the court to read. And the key sentence for my purposes, but there's all the difference in the world between a concession and a failure to challenge. The former will bind the adjudicator, the latter will not. And again, that's the point that my Lady Justice Laing made.
But here we've got a sort of hybrid situation, have we not? It's in paragraph 18 or 19, it said there was a failure to challenge, but then it's being said also that the questions that were asked were tantamount to a tacit acceptance of the status.
But my lady, in the sense that the tacit acceptance arose from failure to put the questions that the FTTJ wanted, I repeat my submission that he wanted it put, you're lying, based on what he recorded. That was not required, and therefore there wasn't tacit acceptance.
Yeah.
And if there had been tacit acceptance, it's surprising that the FTTJ didn't then say to the hopper when she was making her submissions, as recorded at paragraph 13, well, it's not open to you on behalf of the Home Office to say this to me, because I told you that if you didn't ask questions I wanted, you wouldn't be able to. And that is what one would normally expect to see in my submission if cross-examination hasn't been proper, is to say, well, it's not open to you to make that submission. But it's clear that there was no acceptance, that the account was correct. And the FTTJ, if he was labouring under that misapprehension and wanted clarified, should have said, well, I put it to you that you can't pursue that line because of not asking the questions that you've asked. It doesn't appear that that was done. So that is the case of NR Jamaica. We then have another Court of Appeal authority, Maheshwaran, which is at tab 16, page 242. At least that is where the relevant paragraphs are that I would like the court to look at, which are paragraphs 28.
Sorry, this isn't the main bundle of authorities.
Yes, my lord. I will only be referring to the one bundle of 532 pages, because I don't have the other one.
So, Maheshwaran.
And it was which paragraph?
28 and 29 on page 242. So this was a case about procedural fairness in immigration appeal before an adjudicator, and protection status was sought on the basis that the sister of the appellant was a member of a Tamil militant organisation, and that he'd been arrested and tortured because his involvement was also suspected. And the adjudicator didn't accept that his account was credible in respect of the alleged torture, albeit there was medical evidence of a past injury. Now, paragraphs 26 and 27, which precede, record the questions asked of the appellant about it by both the Home Office and the adjudicator. And then paragraph 28 sets out the judge's conclusion, granting judicial review of the adjudicator's decision, because obviously this was the point where judicial review was how you appealed the decision, rather than to an upper tribunal. And it was appealed. It was challenged on the basis that the Secretary of State had not sought to challenge the evidence about torture. And then paragraph 29, you'll see that the Court of Appeal rejected that analysis. It is clear from the determination and its record of the submissions that the credibility of the claimant was an issue. The Home Secretary was in no position to lead evidence to contradict the claimant's account, but it does not follow that he accepted that the injury had been suffered at the hands of the army. So, drawing out the parallels to this case, the Secretary of State is not in a position to lead evidence contradicting the assertion of the 2019 relationship, but it had put the credibility of the torture account in this case the relationship account, in issue, and it was not a public law error, or it was not a basis on which, in this case, a High Court judge on judicial review could say, well, it was erroneous then, if the Secretary of State hadn't actually directly challenged this account for the tribunal to say, well, this account didn't happen. My Lady Justice Asplin, you're looking slightly confused.
Can you repeat that for me on the basis of paragraph 29 of this authority. Just tell me what your submission is again.
Yes. So I appreciate I rattled through the background slightly, but
No, I understand, and it's about what is being said is it was a question of credibility there.
yes.
It was about whether you were tortured or you
Yes.
weren't, and because of that, because it hadn't been challenged, the Home Secretary was in no position to lead evidence to contradict the account, but it didn't mean that that the Home Secretary accepted the account.
Yes.
Now, what was your submission, and how does one translate?
So my
that
lady,
to
the
our
submission
position?
is that you can put in issue the credibility of an account. You can make it an issue in proceedings as part of the adversarial nature of the appeal process and to assist the tribunal. But you don't have to put questions challenging that account, in this case, because you didn't have, the Home Secretary didn't have a basis on which to cross-examine an account of torture that had happened in another country. And the High Court effectively said, well, Home Secretary didn't ask questions to challenge this account in cross-examination, therefore it wasn't open to the tribunal to find it incredible. And this is the Court of Appeal saying, well, no, because the credibility was an issue. The fact that the Home Secretary didn't seek to controvert the evidence in cross-examination doesn't mean that it has to be accepted that the injury had been suffered in the way the appellant alleged. And the takeaway for the purposes of this case, bearing in mind that questions were put which challenged the credibility of the account about the relationship, is the same. The Home Office doesn't have to say, well, that account's false, in order to challenge, to keep it as a principal controversial issue and say, well, it hasn't been made out to the relevant standard of proof. And I should say that the Court of Appeal also made that point again in paragraph 2, going back to the start of the judgment, which is on page 234, the Court of Appeal judgment, where they effectively give the answer at the beginning and then come back to give it in more detail. And you see it there. It was submitted on behalf of the claimant that if the Home Secretary does not challenge an assertion of fact made by a claimant before an adjudicator, and the adjudicator does not raise with the claimant doubts about the veracity of this assertion, the adjudicator is bound to accept that assertion as proved. If not to do so may be material to his determination. In that submission, in our judgment, that submission is far too broadly framed. And my submission is that that's actually what the judge did. Said, because the Home Office is not controverting this, therefore I'm bound to accept this account. But that was not the case. And my lady, conscious of time, I'm not going to take you into it in the way I would have done. But the other authority that goes to that is the case of Hisseni, which is a High Court case, and the relevant paragraph of that.
Where do we find that?
So that is in the authorities bundle at tab 18, page 44.
I know that you are constrained for time, but do take us to whatever is the appropriate parts of this. Don't.
My lady, I'm grateful for the indication. So while I catch myself up, I've given the wrong reference for the page. My lord, my ladies, I apologise. The correct is 269. And paragraph 42. Hisseni was about a Kosovan applicant for asylum who alleged risk of harm on return because of a refusal to join a militant organisation there. And the adjudicator found his decision not to be credible because, effectively, the appellant had considerably embellished his account as to risk at the hearing. And the point is made in paragraph 44 down the page that the Secretary of State might have elected not to cross-examine, but might still have made submissions challenging credibility because it had been put in issue. And the High Court doesn't take any issue with that course of action for the reasons given in 42. No acceptance of credibility by the Home Office. There's simply no dispute to what was said. So that is a difference that goes to my point about it's different. Not controverting is not the same as accepting. and I'll deal very quickly because I've already addressed it to a certain extent. To the extent that my learned friend seeks to rely on the case of Allah, which he took you to previously, and that is in the bundle at tab 7. And the paragraphs I'll be asking the court to turn up start at 44, which is on page 78. But my first point, so I'm actually going to ask the court for completeness.
Paragraph 44, you say?
Yes.
Oh,
Is that what you wanted to go to? Sorry.
Sorry, my lord. So paragraph, the paragraphs I'll ask you to turn into first are at paragraph 20, which is on page 88. And I refer you to this in support of my first point, which is that the legal context in Allah, in which the issue of failure to cross-examine arose, which is, as my learned friend said, deprivation of citizenship, was entirely different. And that's clear from this recital of the applicable legal principles which are at those paragraphs. In particular, the fact, and you'll see this in paragraph 22, at the second sentence, that it follows a three-stage process where effectively the burden of proof shifts. It starts off with the Secretary of State, and what must be provided is prima facie evidence of deception, so a different issue from the present where we're talking about balance of probabilities. Having discharged that, we then move to a burden of raising an innocent explanation, which is plausible, and that is on the appellant. And then 3, if that burden is discharged, so if a reasonable explanation is provided, the burden then flips back to the Secretary of State to establish on the balance of probabilities that that explanation is to be rejected. Now that's entirely different as a legal context from the asylum context, where the burden is on the appellant and no finding of dishonesty.
Wait. He's talking about the evidential burden, surely. I mean,
the legal burden of proving dishonesty lies on the Secretary of State.
I mean, the legal burden is always on the Secretary of State in that case, because the thing is, he's talking there about the evidential burden. He's talking about adducing prima facie evidence of deception, then has a burden. He means an evidential burden, surely.
Yes, my primary submission, my lord, is that the burden's on the Secretary of State to prove dishonesty.
Yes, but that's right. But I mean, it's not that the legal burden shifts in the way you.
No,
Well,
It's the evidential burden that
yes,
shifts.
I think everyone accepts that.
Yeah,
Yes.
Okay.
The reason that I take you to that little 3 is because it's really important to understand that as the context for the criticism that was made of the Secretary of State in Allah. Because what had happened in Allah was that there had been the first stage of an allegation of deception, there'd then been an innocent explanation raised at the second stage, and what the Secretary of State then didn't do is challenge that in cross-examination. And you can see that from paragraph 44, which is flipping forward in the decision, and my learned friend took you to this at paragraph 94.
Page 94, yes.
Yes. So what you see is the court here reciting that the Secretary of State have been given multiple opportunities to address deception and dishonesty, and particularly if you go into on to page 95, that the judge involved in the case had warned the Secretary of State that unless the appellant's case, so that's the explanation at stage 2, was addressed, there may be a presumption made that the respondent does not take issue with the submissions contained in the skeleton argument. And then that's when Mr. Malik makes a submission that because it had not been challenged in cross-examination, effectively the Secretary of State couldn't challenge that explanation. And that is the context in Allah in which the Secretary of State was criticised. Entirely different from the present position. Because the burden, evidentially, at that point had fallen on the Secretary of State, and the Secretary of State effectively, for whatever reason, didn't engage with that.
So dropped the ball on 6 occasions.
Yes. And then tried to say, well, we challenge it, but hadn't done the work it needed to do to make that position.
And here you say the evidential burden is on the person in question.
Yes.
And the question is on the balance of probabilities.
Well, the legal burden.
Yeah.
both burdens
Legal,
Yes.
legal and evidential.
fall on
burden.
the appellant to establish that he is gay in the context of this being his second asylum claim. So he needs to show that there is a reason why the first asylum claim findings in 2017 shouldn't stand. The point that was relied on to do that was this 2019 relationship with Mr. K. So he needed to prove that his account of that relationship, which is a long-term relationship established, cohabiting like marriage, was true on the balance of probabilities.
I fully accept the legal burden was on him to show that he was gay and was in a relationship, a homosexual relationship. Understand the legal burden is completely on him and never shifts. But the evidential burden is normally said to be sufficient. It's discharged in the first instance by adducing sufficient evidence which, if believed, could found a decision to that effect by the finder of fact. In other words, you have to raise evidence which, on its face, if believed, is enough to leave it to the finder of fact to make the decision on the point in issue. Why didn't, in this case, the appellant do that by putting in a witness statement that said, I am gay and I'm in this relationship?
Because
If nothing else had been said, are you saying that that of itself was insufficient to discharge the initial evidential burden, the evidential burden properly so called?
yes, because
Why?
if a witness asserts, I have a subsisting multi-year relationship with an individual, in one line in a witness statement, and then says, I can't prove it, sorry, because I lost my phone, that is not sufficient evidence in the Secretary of State's submission to discharge the burden in an asylum appeal in the anxious scrutiny context and against findings from the 2017 proceedings that he was not a credible witness.
Right.
That was the background.
But does that mean that you are, in essence, saying that we're into a situation in TUI that the evidence that was put forward was inherently incredible?
No, my lord. What I'm saying is that the judge, in exercising his Rule 14 discretion at the point that he did, deprived himself of the proper opportunity of assessing the evidence in the round, including matters which would patently have gone to credibility, particularly in respect to the evidence of Mr. K. Because if Mr. K had stood up and had been asked questions, can you effectively along the line that the appellant had set out, and he hadn't been able to answer those questions to the satisfaction of the tribunal, then that would have been relevant. That was different. But the judge, in exercising his Rule 14 discretion on an improper basis, because of his assessment of a failure to ask questions which he effectively treated as a concession, deprived himself of that opportunity.
Right, but just to be clear, you're not saying that the evidence that was put forward by the appellant was inherently incredible,
No, my
so
lord.
we're into one of the exceptions.
No, my lord, I don't rely on that exception in TUI. What I would say is if we do embark on engagement with TUI, despite the fact that the Upper Tribunal didn't make any finding about notice, then we're more likely in the sixth situation that my learned friend took us to previously. Now, that sixth situation, which we'll come to in a moment, was phrased in terms of expert witnesses in Part 35. But in my submission, that rationality applies to a similar extent in circumstances where in official documents relevant to proceedings, an issue is raised that goes to credibility, the person is given the opportunity to respond to it and doesn't. Now, in his witness statement, the appellant, as you saw, Mr. Gadjar took you to it in detail, addressed issues of credibility that had been raised. He didn't deal with the issue of bank statements, receipts, and so on. He just said, I don't have my phone anymore. So he had the opportunity in his statement to deal with issues that had been fairly put in the refusal decision, and he didn't. He would have had the opportunity to address those in examination in chief if his representatives had wanted to, and if they didn't, the HOPO obviously did start to raise them, or did raise them, in a way that she considered sufficient, but see, the first-tier tribunal judge didn't agree. Going into TUI, and my lady, I'm reminding myself of the time, as I've made the point about the ground of appeal, and I won't make that again, but I will make the point that the Upper Tribunal's decision and analysis of the authorities leading up to TUI disclosed no material error of law of the kind my learned friend appears to be saying. The case law that was reviewed clearly established that the issue of procedural fairness turns on whether the witness was given fair opportunity to respond to challenges to their evidence, which the other side seeks to rely on. Trite law, it's a fact-sensitive question. And before I turn into the authorities, my submissions are briefly this. That fair opportunity may and usually is achieved by putting the point in cross-examination. However, as TUI recognised, and so did Chen, and my learned friend took you to the relevant passages earlier, that's not mandatory. Notice can be given by other means that is sufficient. And that was the position confirmed by the Supreme Court in the case of TUI. So turning back into TUI, it's getting a bit worn out. Tab 4, and the first paragraph to look at is 36, which my learned friend took you to, and that's on page 27. And to the extent that this court is going to entertain Mr. Gadjar's submissions about the legal correctness of the Upper Tribunal's analysis of notice authorities, I would invite the court to read this analysis from 36 onwards in full. But I'll pull out some key passages which I say go to the Secretary of State submission. So the first of those is paragraph 46, which is on page 33. And here we have the Supreme Court considering the case of Brown-Dunn, so the seminal case which gives rise to the name for the rule about which we are all taught at bar school. And I'd invite the court to read those paragraphs in full, so 46 to 49. And the takeaway from that is that at the core of Brown and Dunn was notice. And Lord Herschel says that there's no need to do that by cross-examination, where it's perfectly clear that you have prior notice that you intend to impeach credibility, and in this case there was clearly that notice. Not that this court needs to make a finding of that nature, because it's a finding of fact, and the Upper Tribunal didn't go that far either. And then turning forward in TUI, we have at paragraph 52, so on page 34, a review of the Markham case. And of particular relevance are the quotes that have been pulled out by the Supreme Court, which are on page 35.
I mean, this is a different point than notice. I mean, notice is one point. This is a different point. There's no suggestion is there here that this is just a case of lack of notice. I mean, this is where this is all to do with fairness to, or fairness of the trial process to the parties and their witnesses. That if their evidence is going to be disbelieved, they must be given a fair opportunity to deal with the allegation that they're lying.
Yes.
I mean, that's a different point than notice, isn't it?
Notice, the Upper Tribunal set aside the FTT's decision because it held that in deciding whether to exercise the Rule 14 discretion, the judge should have, in having concerns about cross-examination, nevertheless considered the issue of whether the appellant was properly on notice that his credibility was an issue. And my learned friend seems to be saying, well, that was wrong, even though his grounds of appeal don't say that, neither does his skeleton. And my submission based on these is that that is not true in law. That's not correct. If you are put on notice that your credibility is in issue, that is what procedural fairness requires. And going back to Lord Herschel, in the seminal case at paragraph 46, that doesn't have to be by cross-examination. if it's clear that you have prior notice that the opposing party intends to impeach your credibility. So what the Upper Tribunal was saying is, well, before it got rid of all the witnesses and put a full stop at the end of the appeal, the FTT should at least have considered whether there'd been sufficient notice to overcome the perceived deficiencies in cross-examination, which the Secretary of State obviously says were not deficiencies at all. So, my Lord, respectfully, I think these paragraphs do go to the relevant point that the Upper Tribunal
So you're saying that the principle is that if you're on notice that your credibility is an issue, you do not need to be cross-examined on your evidence.
It is not mandatory in the way that my learned friend seems to be saying. So the Brown-Dunham rule is not, you have to have absolutely everything put to you ever.
But is there even a general rule that you should be?
Not cross-examine, no. The general rule is that for a case to be procedurally fair, you should have been put on notice of the issues that might be determined against you, or the basis on which the court might be asked to find against you, for the obvious reason that you need to respond before the court makes its decision. So that is what procedural fairness requires. As I said in my submissions earlier, that is usually done by cross-examination, but for the reasons that the Supreme Court reviewed in TUI, in the Chen context, for example, abbreviated trial time, that might not happen.
But if you're right about that proposition, how do you account for paragraph 70 sub-rule 1, which sets out the general rule? It doesn't say the general rule is that if you are put on notice that your credibility is an issue, then you don't need to be cross-examined.
So
71 is put in a completely different way, isn't it?
But the important corollary to paragraph 70 little 1, and my ladies, we're on page 40 now, is little 6 and little 7 and little 8. Particularly little 7, the rule should not be applied rigidly. It is not an inflexible rule, and there is bound to be some relaxation of the rule. And there, it's not talking about exceptions, because exceptions are dealt with separately at 8. And one of those exceptions, as I've said, which is 6, which is at paragraph 67 on the opposing page, is a situation where proper notice has been given already. So, my Lord, no, the Supreme Court didn't find with respect that there was an inflexible rule.
I'm not suggesting they did ever find an inflexible rule, but they did say there was a general rule.
Yes.
And the general rule isn't in any way expressed on the basis that, provided you've got notice, you don't need to be cross-examined.
No.
Your proposition, as I wrote it down, was that the principle that you extract from all these cases, TUI and the others, is that all that fair procedure requires is that you're on notice that your credibility is an issue, and that's the end of it. You then don't need to be cross-examined either as a general rule or inflexibly. And I was just putting to you that doesn't seem to be the way that the Supreme Court, Lord Hodge, viewed the rule in paragraph 70.
Well, the litmus test, this is the Brown and Dunn rule is fundamentally about procedural fairness. Procedural fairness is fact-specific, which is why you can't set hard and fast rules. I mean, the general rule is that you're required to challenge by cross-examination the evidence. That's what little 1 says. But then it says, in the paragraphs I've adverted to, that there are some circumstances where that doesn't have to be the case for a procedure to have been materially fair. And that would require an assessment of the facts of circumstances where a decision has been made based on points that weren't raised. Because then you would say, okay, well, what ultimately did the judge rely on, the points relied on, and what notice was given there of those specific points. But here the court can't make that assessment because the first-tier judge stopped the exercise before he got to that point, because he used the Rule 14 power to cut off the evidence prematurely, the Secretary of State says. And, my Lord, this is why I think the Upper Tribunal sensibly didn't engage in the exercise of, had there been proper notice, if the FTT had accepted the Secretary of State's account, would there have been proper notice? Because it was a counterfactual position. It hadn't happened, and the Upper Tribunal didn't want to enter into findings of fact. It just said that if there were procedural unfairness concerns on the part of the first-tier tribunal, it needed to properly address its mind to what they were, and it didn't. Instead, with respect, the tribunal had a knee-jerk reaction to perceived inadequacies in cross-examination, which you have my submission were not inadequacies, and cut itself off from carrying out its proper exercise of assessing all the evidence in the round. It didn't grapple with the question of procedural fairness, and that is the error that the Upper Tribunal found. It didn't find that there was or wasn't procedural unfairness. It said you needed to grapple with this, and you didn't. And therefore, your discretionary exercise of the Rule 14 power was vitiated by error of law.
Where are we, Miss Elliott?
I'm going to turn very quickly, given the time, to the respondent's notice.
Well, how much longer have you got? That's the question.
So I'd planned for this to be about 20 minutes, but obviously we are.
And then we need a
different
reply.
Circumstances, yes. I would.
Let's carry on.
I'm grateful. So turning then to the respondent's notice argument, dealt with at paragraphs 34 to 40 of my skeleton. And this deals with really the implications of paragraphs 22 to 25 of the FTTJ's decision, where it set out its own concerns as to credibility, and those should be taken together with the inconsistencies that it recorded in the preceding paragraphs leading up to paragraph 19 that it had identified from the oral evidence of the appellant. So in those circumstances, the FTT judge was not required to put those in a strange postscript and not grapple with them. It was in fact required to deal with them itself. And it was not prevented from putting them to the appellant because the Home Office hadn't done. And I think this is particularly relevant about the GP letter issue, because that was a credibility concern that was not part of the Home Office's case, but it was a clear concern for the judge, and it should have been resolved as part of the determination of the asylum appeal.
Can I put to you again the point that before? I mean, you start paragraph 20 of your skeleton. The sections you were asking us to look at to describe the first tier tribunal as having an inquisitorial function. I just want to understand what you're saying there. I mean, I understand entirely that, as you say in 21, the FTT is entitled to put questions to a witness in order to clarify issues. But that would normally be to clarify evidence that's been raised, or to clarify that the position of the parties on the issues in the case. In other words, to ask counsel, are you saying X? But is your submission going further than that, to say, irrespective of whether one side has, for whatever reason, asked questions, that the FTT has a duty or an obligation to, as my lady put it a bit earlier, take over and say, well, I know you haven't asked these questions, but I'm going to, and then go on to do so.
So to be clear,
sorry, aren't you making a slightly different point, which is that if the FTT, in its review of the evidence, identifies points in the evidence that aren't relied on by either side, but by which it is evidently troubled, as is the case here, then it should give the witnesses an opportunity to comment, because otherwise you've got this paragraph hanging at the end of the decision, which implies that the letter's a forgery, but makes no findings and hasn't put it to the appellant.
my lady, yes. To answer my Lord Justice Snowden's question, what I'm saying in 20 is, so in an adversarial context, the parties define the controversial issues. Evidence is then adduced. It is the role of the tribunal to determine those issues with reference to all of the evidence in the round to which it applies its own assessment. Now, if in the course of its own assessment it identifies issues of concern to it, which go to credibility, bearing in mind, particularly in this context, we're dealing with a second asylum claim. So on the slate of the FTT, if I might use that image, you have chalked up already adverse credibility findings that have to stand. If it has credibility considerations of its own, it needs to put those.
But does it, surely there's a logically prior point. Surely if, like any trier of fact, if you are concerned about a fact, obviously should raise it with the parties. You know, I'm concerned that there is this question, and give the parties the opportunity to address it.
Yes.
But if, for example, a party says, I don't want to address it, is there then an obligation upon the judge to say, well, I know you've just said you don't want to, but I'm going to start inquiring and asking questions myself? Because there are many cases, particularly in the criminal context, but also in the civil context, where a party may not want to ask particular questions for very good reason, which the court may not know. But are you saying that the trier of fact in this particular situation has an obligation to go on and actually get to the bottom of the point that troubles it, irrespective of whether the parties take up the opportunity to do so?
If it goes to a principal controversial issue which the court is being asked to determine, I'm not saying that it's obliged. I'm saying that.
Well, you are saying. I thought.
Yeah,
you were
my lord, I think I am.
Yeah,
I am
you were.
saying that they are obliged. In an asylum context, we must apply the anxious scrutiny standard, and that applies to the account of the person seeking asylum, not just to anything said by the Secretary of State.
Have you got any authority for that proposition?
Yes, my lady. I was
Is it mentioned in your skeleton?
yes.
Okay, that's fine. I'll pick it up.
It's what Lord Carnwath quotes in MN and KY. And my lady, I'm going to take you to it. I'm in my sort of summary phase at the moment. This is a situation where credibility was front and centre, and the account was being put by the appellant was backed up by evidence, which it was asking the court to accept. Now, the GP letter is important because it was the evidence about the shared address between the appellant and Mr. K. That was a crucial piece of evidence which the court had concerns about, and my lady, Justice Laing, has given her impression of what those concerns were. They were quite significant. And this was also in a context where the adverse credibility findings made in 2017 included that witnesses who'd provided letters supported effectively just regurgitated what they'd been told to say on behalf of the appellant, which is a credibility issue as well. So it's clearly a germane point, and in the context that the FTT was dealing with, it should have put it. And the fact that it didn't do so, but thought it was important to record it in this weird, apologies, peculiar postscript, it's just difficult to reconcile with the function of the tribunal in an asylum context. Going then into bearing in mind the time, the relevant cases. So we start, as I mentioned in response to my lady's question, with MN and KY, which is in the authorities bundle at tab 5, page 46. Now, the facts aren't relevant for present purposes, but it was about the use of linguistic analysis reports by the Home Office. But I want to draw attention to Lord Carnwath's analysis of the first tier tribunal's role in asylum claims, which is at paragraph 25. And the first two sentences I'd ask the court to read. And that is the authority for the proposition that the first tier tribunal has a slightly different function than civil proceedings. And then we turn at paragraph 31, which is on the next page, to the authority for the proposition that anxious scrutiny works both ways, as I submitted previously. So that relevant sentence in paragraph 31 is over the page on 59, and yeah, it's stated in the words that I used.
Oh, that's very helpful, thank you.
Well, I'm grateful. And then, so what the court should take away from this is that the FTT, in carrying out its function, must apply the anxious scrutiny standard to the narrative and is not bound to accept accounts which do not appear to it to be credible. We then turn out of MN and KY to the case of Abdi, which is at tab 8 on page 96. And by way of summary, this was an appeal against a refusal of EEA family permits under the 2016 regulations, which the FTT dismissed on appeal because it found that the appellants had not shown themselves to be financially dependent on the sponsor, which was one of the criteria for them obtaining the permits, for reasons which called into question the credibility of the sponsor, who said he'd made certain regular payments to them, so that was part of the factual matrix relied on to establish financial dependency. And the appeal to the Court of Appeal was that the credibility issues were not put to the sponsor by the tribunal in circumstances where the refusal decision by the Home Office hadn't identified those as being credibility issues, so unlike in the present case. And in those circumstances, where no notice of any kind had been given that there were credibility concerns, the Court of Appeal found that there had been procedural unfairness. What's helpful for present purposes is the recitation by the Court of the relevant principles, which starts from paragraph 29 on page 104. And starting in 29, we go down to the end of the paragraph on that page 104, which talks about the normal principles in terms of procedural unfairness, and then says the tribunal may identify an issue which has not been raised by the parties to proceedings, but it will be unfair for it to base its decision upon its view of the issue without giving the parties an opportunity to address it upon the matter. As an expert body, and it's talking about the FTT, the tribunal is entitled to reject evidence, notwithstanding that the evidence has not been challenged before it. Fairness may, however, require it to disclose its concerns about the evidence so as to afford the parties an opportunity to address them. And then it makes the point, the final sentence about notice, where an applicant can generally be expected to be aware that the tribunal will have to assess their credibility. There will generally be no unfairness in a tribunal proceeding without drawing attention to a point which the appellant could reasonably expect to be plainly relevant to that assessment. In this case, obviously, the relationship was an issue that was plainly relevant to the determination. So there is no prohibition, in light of those authorities, on an issue being raised about credibility by the tribunal in the discharge of its proper function, as long as it does so in a way that's procedurally fair. Now, we can't assess procedural fairness on the facts of this case because the counterfactual scenario of the judge actually conducting an analysis of all the evidence in the round didn't happen. But there was, to the extent that the judge thought he was prohibited from putting these concerns because of the position of the Home Office, that's just not correct in law.
But sorry, just reading on in that authority, I don't know whether you're going to read on, but what I read that authority as saying is that if the adjudicator, I mean, there's a reference there to paragraph 31, if the adjudicator or the tribunal is concerned about points relating to credibility, the requirement is to point them out to the representative and ask that they be dealt with either in examination of the appellant or in submissions. I mean, it doesn't go on to say that the adjudicator or the tribunal actually has to descend into the fray and do it itself if, when asked to deal with it, the representative declines to do so. I mean, yours is quite a. It's quite a long way from this sort of situation, because you're saying that even in a case where the judge is concerned about matters and asks them to be dealt with by a party represented in front of it, and the party declines to do so, the judge nevertheless has an obligation to go on and do it for themselves.
But my lord, with respect, I'm not saying that. What I'm saying refers to paragraphs 22 to 25, which are credibility concerns that the Home Office was not raising, particularly in respect to the GP letter. This isn't a situation where the judge said to the Home Office, what about this GP letter? Are you not concerned about that? And the Home Office said, no, there's nothing to see here. the judge had clear concerns which could potentially arise to this is a fraudulent document and didn't put them. So there was nothing said by the parties which found it. It just didn't raise it at all.
But I understand why. A judge couldn't conceivably make findings of fact or found a decision on, for example, the GP letter by saying it's a forgery, where that had not been investigated. Which I think is what these cases are all about. I mean, these are cases where, a judge, before they found a decision on a particular evidential basis, has an obligation to raise it with the parties and have it put to a witness or have it properly investigated. I mean, that's really what these cases are about, isn't it?
But your point is the FTT deprived itself of the opportunity to look
Yes.
at any of these points by seizing on the failure to put in cross-examination, you aren't gay, are you, to the appellant, and then just abdicated its responsibility to give anxious scrutiny to the claim.
My lady, yes. And I think this is where my learned friend submissions about notice are difficult, because we don't have a situation where we're dealing with procedural unfairness to the appellant. We're dealing with procedural unfairness to the Secretary of State because it was deprived of the opportunity to interrogate the evidence of Mr. K. And also, beyond that, an abdication by the FTT of its own function in the context of an asylum appeal to determine the issue of whether, on the basis of balance of probabilities, sexuality has been established, based on which you're then eligible for refugee convention protection or you aren't. And it didn't do that. My lady, I am conscious of the time, but and because it's an Upper Tribunal authority, I'll just give you the reference. In paragraph 21 of my skeleton, I give various references to immigration appeal tribunal decisions, what is now the Upper Tribunal, and the only one I'd invite the court to look at in this context is the JK Côte d'Ivoire case, which is in the authorities bundle at tab 23, page 361, and the paragraphs are 42 and 43. In fact, I will crave the court's indulgence to go to this, because it deals with my Lord Justice Snowden's concerns. So paragraph 23, page 374 is the paragraph that I would like the court to look at. And yes, paragraphs 42 and 43. And what I'll place particular emphasis on is the comments made that start towards maybe 2/3 of the way down, even where, because as the court may be aware, there's a slightly different position prevailing in cases where the Home Office does not appear, and that's governed by what are called the surrendering guidelines, which we'll see referred to in various of the cases. But what is being said here is even where the parties are both represented, it's still relevant for questions to be put by the adjudicator, so the equivalent of the FTT as it then was, to a witness if they raise matters which trouble the adjudicator if they've not been raised or dealt with by the opposing advocate. This is especially so if the adjudicator is concerned by the point and it is something which may affect the decision or indeed should affect the decision, but cannot fairly do so without the relevant witness being given the opportunity to deal with it. And then the corollary to that is given in paragraph 48, which is effectively, if you're going to do this, please do it fairly. I don't think there's any dispute about that. So in this case, credibility was an issue, the relationship was an issue, and the concerns raised in the postscript go directly to that. And this is why in my submission, in this case, and I only have to deal for the purposes of my point with this case, I'm not trying to make a general proposition here, they should have been put so that they could have been dealt with, but they weren't, because the tribunal misdirected itself as to the correct legal position.
And do you say, therefore, I mean, it's the point that my Lady Justice Laing made, you're saying the FTT judge deprived himself of all of these opportunities because he put the portcullis down when he did.
Yes.
But you're saying, are you, that if he hadn't done that, he could have asked the Hoppo about these issues, and she may have taken them up. And if she didn't, he should have done.
Yes, my lady, yes. Because I'm conscious of the time, and I've covered it a lot, I would say that the context of this case as a second asylum claim adds force to my submission. We've seen the quotes about anxious scrutiny in MN and KY. The credibility of asylum claims must be properly assessed by decision makers. And the case of YH, which he was quoting from, I'll just ask the court to turn up, which is in the authorities bundle at tab 10, page 122. So in terms of the facts, this concerned an Iraqi Kurd who claimed asylum on the basis that he feared risk on return.
Sorry, give me the page again.
Page 122, my lord. He claimed fear of risk on return because of involvement in the illegal sale of antiquities, a mummy to be precise, and that claim was refused, and the appeal failed largely on the basis of credibility. And he made a second claim on the basis of the same account, but with the additional allegation that he'd been detained and tortured in his home country as a result of the activities. The Home Office refused to accept that as a fresh claim, and the court considered various issues, one of which was the meaning of anxious scrutiny, and that is the quote that was given about in paragraph 24. So that is on page 130, and we've already seen that it was what was quoted in MN and KY, so that's really for the court's note. But what I would ask the court to look at is paragraph 14. Now that, because the court's dealing with the specific context of credibility in the Diva Sealand context. And this is really the point I want to take away, is that where adverse credibility of claims have been, findings have been made in the original proceedings, those carry through not just the individual points, but the fact that the witness was not, the appellant was not deemed to be credible. That's a material factor for anyone considering the second claim. And with respect to the FTT, although it acknowledged that there were those credibility adverse findings in the 2017 decision, it just recited them and didn't do anything with them. So turning forward in YH onto page 134, we then see how the court dealt with this on the facts of this case, and that's at paragraph 42 and 43. And particularly 43, the decision maker was entitled to start from a position of extreme scepticism, given that the previous claim had been rejected by an adjudicator as wholly incredible. There was no reason to expect his credibility to have any greater weight for an immigration judge on this occasion unless supported by corroborative material, or at least plausible detail. And that, I think, is particularly relevant to the concern about the GP letter, because that was advanced as corroborative material. And if there was doubt in the mind of the judge about the validity, putting it neutrally, of that evidence, that was a significant factor which was not dealt with. Dealing very briefly, and I can't see a clock, so I don't know what the time is, but with the, I'm aware from my lady's facial expressions that I'll need to be quick. The final point on the respondent's notice is the Robinson obvious point, because this issue about the FTT depriving itself of the opportunity to deal with evidence was not raised as a ground of appeal in front of the Secretary of State. I can give the court an easy shorthand about what my submissions are, because I've already made them before this court in the case of SA, which is at Authorities Bundle, tab 6, page 78. Now, the context of in which I made those submissions was different, because we were dealing with humanitarian protection, not refugee convention. But what I'm effectively saying is that the arguments that the court accepted in SA about Robinson obvious principles being open to the Secretary of State rather than just the appellant, because it has been said in some cases, well, Robinson obvious points can only ever be invoked on the part of the appellant.
Some trouble with this submission because, I mean, I've reread Robinson recently and it's very much in favour of somebody who makes a refugee convention claim, and it has to be an obvious point and not a merely arguable point, but one with very strong prospects of success. I'm only aware of one case, also a refugee convention case, in which the Secretary of State relied on it, and it was a case about loss of refugee status. So I'd need to be persuaded that that it is more than a sort of general point floating in the ether, because I don't think it is.
Yes, my lady. So going to the case of Iraq, which is the Court of Appeal decision, which SA was a case about the cancellation of refugee status, where the court didn't need, it was obiter, but the court accepted that the point could be invoked in favour of the Secretary of State, and it did so partly on consideration of the case of Iraq, which is in the authorities bundle at tab 13 on page 199. And the issue,
this is the one I'm thinking of.
the one my lady's thinking of, I'm grateful, and that, as my lady says, is different. It's about the mandatory exclusion criteria from refugee status of someone who has a self-confessed torturer, and the issue was whether Robinson obvious could be used to raise that, and the Court of Appeal found that it could. But what I say applies with equal force is the reason why the court in Iraq was happy to extend the benefit of Robinson obvious to the Secretary of State, and that was really its analysis starting from paragraphs 18 on page 204 about what is the heart of the Robinson Doctrine. And my lady, I'll invite you to read these paragraphs in your own time, but fundamentally the essence of the Robinson Doctrine is what is set out in 20. It's a quote from Robinson, that it is the duty of appellate authorities to apply their knowledge of convention jurisprudence to the fact as established by them when they determine whether it be a breach of the convention to refuse an asylum seeker leave, and that they are not limited in their consideration of the facts by the arguments actually advanced by the asylum seeker or his representative. So at the heart of this, and you'll see the court distilling that on page 207, paragraph 27 and 28, is the duty on appellate authorities to apply their knowledge of convention jurisprudence to the facts established by them. Now that duty obtains in all cases equally, regardless of who that duty might be adverse to, whether it's the asylum claimant or not.
Well, but the rationale for the Robinson Doctrine is that not to have it would amount to a breach of the Refugee Convention. At the moment, what is the potential breach of the Refugee Convention that would arise from not allowing the Secretary of State to rely on the Robinson Doctrine in this case?
My lady, it goes to the heart. That question goes to the heart of my submission. So, the judge failed to discharge the task that is given to appellate authorities to ensure compliance with the convention, i.e., an analysis of the evidence presented as a whole to assess whether on the balance of probabilities the factual matrix underlying the asylum claim is made out, and therefore whether the breach of Article 3 in this case is made out, because that's the basis on which you obtain protection.
Well, I see the way you put it.
Yeah. So effectively, if you interrupt yourself in that exercise and you leave it undone, you are giving rise to a risk of a breach of the Refugee Convention in conferring.
Well, no, it's not a breach, but it's not a breach. The breach arises where someone's entitled to asylum and you fail to give them refugee status. It seems to me that's the breach that Robinson is concerned with. But I mean,
my lady, I apply the flip side of the coin.
Yeah, no, I see.
Applies equally, and that was the submission that I made in the case of SA. Which was about cancellation, and I'd invite you to read those. And just a quick other reference for the court's note, which is Balale, which is the other case I refer to in my skeleton. But the relevant paragraph is paragraph 24, and it's in the authorities bundle at tab 11, 137. That is the case. The paragraph itself is on 143. And it's the court accepting that the essence of the doctrine is. And in that case, it was held that it was accepted that it could apply to the Secretary of State. And indeed, in Bilale, it would have been open. The court was satisfied that it was open on the basis of Robinson to look at EU law, not just convention law, because that's an international obligation as well. My lord, my ladies, unless I can be of any further assistance, those are my submissions.
Thank you very much indeed. We're sitting long, put it that way. How long will you be? I don't in any way intend to constrain you.
I'm content to be held to a 10-minute marker.
If you're content with that, then I think we should do it.
And I am grateful to the court for sitting through the short adjournment. The court, of course, has my submissions. I'll start off by the allegation that the appellant has sought to expand the grounds. That point is denied. Paragraphs, from my own skeleton arguments, paragraphs 20.3 and 21 are relied upon as building the ground upon which permission was granted in rather wide terms. And, of course, the appellant also has the right to respond to the points made by the Secretary of State in her respondent's notice. My second point in reply focuses around the issues around NR Jamaica and the questions of concessions. The appellant would emphasise the point that this is not a case focusing upon concessions. The judge does not proceed to allow the appeal by saying that Ms Shah, who represented the respondent, had conceded the point in some way, but does so on a far more nuanced analysis of the cross-examination, and the point being made that not enough was done for that cross-examination to undermine the appellant's evidence. That's how I'd invite the court to read the first-tier tribunal's determination. The appellant has relied, this is my third point on ULA, the Secretary of State's riposte to that is to identify the specific burdens of proof that arise in cases where the Secretary of State makes an allegation of dishonesty. That is a distinction which, for the purposes of this appeal, is one without a difference in my submission. True it is that in ULA the burden is upon the respondent. That does not change the application of TUI. TUI itself, of course, was a matter in which the burden was on the claimant, and it was the claimant's expert report provided by Professor or Dr. Pennington, I forget, and I apologise, which was the subject of criticism by the trial judge, despite the absence of cross-examination on it. Now, the Secretary of State, the overarching point here is that whilst it's been put to you that the presenting officer did challenge the relationship, that, respectfully, my submission is not how Judge Carton appears to have read it. And when one looks at the respondent's minute, this is within the bundle that contained NR Jamaica, paragraph, pages 24 onwards. That first page at page 24 records that the appeal was allowed orally. Any concerns if this appeal is to be allowed? The answer to that was marked as no.
My lady, just to be clear, what that means is, does this case have any wider implication? It doesn't mean, were there any concerns about how the tribunal presented or dealt with it, just to be clear on what that is.
So let's just go back to page 24 and perhaps you'd repeat what you just said.
My lady, I do nothing more than to introduce this document to observe that the presenting officer had marked that the appeal had been allowed, with there being no concerns about the appeal being allowed. You've heard from my learned friend on that point. My key target here is page 25. This is the minute of what's happened during the course of trial. The presenting officer begins by saying that she challenged regarding the witness statement about not having contact. Everything else that follows isn't marked as a challenge. It's asked about when A realised he was gay because he was inconsistent. That's not a challenge. It's asking about various other factors, and given the time I won't go through and labour the point on all of them. But that's the basis upon which Judge Carton ultimately reached the conclusion that there had not been a challenge to the relationship or an assertion that it was a fabrication. Now, the appellant is not saying that appeals of this nature require the Secretary of State to do what we're taught in bar school of, well, you're lying, aren't you? And my learned friend says if that had been put, it would have been of no utility whatsoever, because the appellant was unlikely to accept that he was lying if that was indeed the case. There are 2 points to be made in respect of that. Judge Carton is not saying that what was required was one missing question about putting it to the appellant as to whether or not he was lying about his relationship. What Judge Carton was noting was the absence of any substantial challenge to the relationship, which is borne out by the minute as presented before you. The second point, even if I'm wrong on what I've just said, is even if my learned friend is right and the appellant in this circumstance would not have acceded and effectively said, yes, I'm lying, that of itself does not allow the parties to dispense with the requirements of procedural fairness. And that's an important point to make when one looks at the authorities, TUI and Chen providing wider guidance, the others in my submission dealing with nuanced facts in themselves. The common thread that goes between these cases and holds them together is one of fairness, whether that's fairness to the Secretary of State, to the appellant, or to the trial process itself. And it's in those circumstances that one has to look at precise facts of what's happened here. Now, my learned friend very probably says she's not trying to make a wider precedent in this case, and nor am I. What we are looking at is an unusual set of circumstances, if I can put it that way, where a first-tier tribunal judge has, on multiple occasions, identified the shortcomings in the cross-examination and given the Secretary of State the opportunity to address them. He doesn't, and it's not entirely clear quite what words were used when Judge Carton has identified the omissions within the cross-examination, but he doesn't have to prescribe questions that have to be put or topics that have to be explored. That should be evident to the parties, especially with the dialogue that had happened in this case. The other point about Tula that I'll make is, the point is made about dishonesty, as the court will recall from TUI, and in particular paragraph 70 Roman 4, the general observations that Lord Hodge had put down in that case included not just allegations of dishonesty, but also inaccuracies and inadequacies in the evidence put forward by a witness. Maheshwaran has been relied upon in this case. That, in my submission, was again a case that was decided largely on its own facts and shouldn't be preferred respectfully in contrast to what's been put forward in TUI and the like. The case before the court today is not one in which there was no notice. It's one with a far more nuanced position about what questions were asked and what questions weren't asked, because we have tacit acceptances flowing from both questions put and questions not put. That leaves me with 2 minutes to deal with 2 final points. One is the reliance on the case of JK, which my learned friend took the court to. Paragraph 42 is important in that context because it's introduced by referring to an adjudicator's duty to clarify, or entitlement to clarify. It is not, in my submission, an avenue that allows, to coin the terminology used by my Lord Justice Snowden, where the Secretary of State has passed the ball and drops the ball on multiple occasions, for the adjudicator to then take that ball and stand at the wicket and do the Secretary of State's job for her. And the final point in my submission goes to the Robinson point, and it can be dealt with in a sentence, where in my submission the overarching position here is that this is not a Robinson obvious point for the reasons that it's not very compelling, obvious, etc., for the reasons set out in Robinson itself. We have a case in which the judge does make some observations, and paragraphs 22 to 25 are such, but they're observations on point the respondent did not put to the appellant, despite having the very same evidence that the first-tier tribunal did. And the judge doesn't say, in allowing the appeal, that this is a case in which his decision would have been swayed had those concerns been put. And with that in mind, unless I can assist any further, I think I'm just 1 minute below my 10-minute mark.
Thank you very much indeed, and thank you to everyone, and thank you to the court staff for sitting through the short adjournment. It was, I think, nevertheless, despite the fact it's gone on longer than we perhaps might have thought, it was better to complete our task. Thank you to you both, as I say, and to those behind you. We will reserve our judgments. They will be sent out in draft form as usual, and I'm sure you're fully aware that we take the embargo very, very seriously. So please don't disseminate them to other people without first asking permission. As you will also know, we circulate those drafts for you to assist with typographical errors and not to re-argue the case. And we also hope that you will be able to agree consequential matters. If you can't agree, we deal with those on paper, as you'll also be aware, and we would ask also, if you cannot agree, therefore, for very short written submissions as to your differences. Thank you very much indeed.
Thank you.